Argument, red light comes on, try to bring the argument to a close. Those of you arguing should have handed in a notice of appearance by now. If you have a cell phone or any electronics, please turn them off and put them away. With the exception at the podium, you may use your electronics. Thank you. Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give the attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have time to answer. We read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When the red light goes on, you should endeavor to stop speaking. We may let you go beyond the red light, of course. So when I call your case, rise and let me know who you represent and how much time you're requesting. Know that about 7 hours of argument time has been requested, and that's not possible. So again, ask for what you need. People via Oscarlito Cruz, submitted. Hendricks versus Finel. And sir? Are you Mr. Finel?
I'm here to respond to Finel's submission.
Okay.
She's here for
All right, 5 and 2 and 5. Thank you. Sir, I'm sorry, I don't understand. Are you arguing as well?
I'm here to respond to Finel, but I agree to submit.
Right, your brief was more or less me too, right? Yeah, okay. So you don't need to, do you want to be heard or you don't need?
That's why I'm just here.
Very good. Thank you. I misunderstood. 5, 2, and 5. M. Justice. Counsel, I'm sorry, I can't hear you.
I would request that the attorney for the father, since he's arguing for reversal, follow appellant.
Very well. I'll give you 4 and 1, 2, 2, and 2. Thank you. Smartmatic versus Fox Corporation.
Appellate Fox Corporation, 8 and 2.
6 and 2 and 6. Black v. Phoenix Cayman Limited.
Appellants, defendants, 6 and 2, please.
6 and 2 and 6 and 2. Thank you. People versus Ralph Myrie.
Appellate press 5 and 2, Your Honor.
4 and 1 and 3. People versus Jared Johnson. Submitted. ST1 Realty v. Caroll.
2 minutes, Your Honor.
Sure thing. Narrain versus Society Pass. 4 and what? 4 and 2. You asked for 8 and 2? I'm sorry, I couldn't hear you. What did, 8 and 2. 7 and 2 and 4 and 2. Thank you. People versus Jimmy Feliciano.
Appellant request 6 and 2, Your Honor. 6 for respondent.
4 and 1 and 3. Lecomte or Lecomte versus Mokrisky. Submitted. Davis versus Adams. 4 and 1 and 4. 477 Realty versus The Wing, Soho.
Your Honor, we require here to seek the permission to move the admission of Mr. Pinker, co-op in chief, and for the defense.
Granted.
On behalf of defendants, appellants, 6 minutes and 2. For respondent, 5 minutes.
6 and 2 and 5. Finel versus Katz.
For appellant, Your Honor, 2 minutes, please.
2 minutes it is. People versus Bayez.
Good afternoon, Your Honor. Appellant request 6 and 2.
5 and 2 and 5. People versus Royce Corley.
People request 5 and 2, Your Honor.
Defendant respondent request 5, Your Honor.
5, 2 and 5. Harper v. De Almeida. I think he's here. How much time would you like, sir? 4 and 1 and 4. Thank you. Cabral versus Mueces is submitted. Petre versus Lucia, submitted. TJT LLC versus Melli, submitted. First case up is People versus Oscarito Cruz.
Submitted. That was submitted.
I'm sorry, that was submitted. So next case, thank you, is Hendricks versus Finel. Ready, counsel?
I am, Your Honor.
Please.
May it please the court. I'm James Newfield on behalf of defendants, appellants, partners in care and visiting nurse service of New York Home Care. The facts before Your Honors are reasonably not in dispute on the issue of causation. This is an appeal from a denial of our summary judgment motion in the trial court, specifically on the issue of causation. Decedent was struck by a vehicle driven by defendant Finel, which propelled another car into her. Decedent at the time was within the crosswalk, had the walk signal within her favor, was exercising due care.
But then, wasn't your employee in charge of caring for this decedent?
She was her aide, and she was not with her at the time of the incident.
Why not? Why not?
Well,
She was required to be with her, wasn't she?
she was, the patient left without waiting for her. This is not an elopement case. This is not a person who was wandering. The patient made the decision while the aide was in the apartment securing her keys to lock the door. The patient made the decision to leave, get on a bus, and go see her daughter.
But counsel, the
without
obvious
waiting for
question is if your employee had noticed that she was leaving the apartment, she could have said, wait a minute, let me get my keys, let me get my coat, and that would have totally changed the time frame.
So that is the issue, changing.
And that's her job,
So
to
her-
stay with the patient, is it not? I mean, that's part of the care
That's
plan.
what, and her testimony is that is exactly what she tried to do. The question is changing the time frame sufficient to establish causation under
Well,
New
there
York?
can be more than one cause of an accident. I mean, we saw the videos and we understand what happened on the street, but there can be more than one cause.
Of course, except the established precedent in New York is one of those causes cannot be merely causing somebody to be at a location sooner or later than they otherwise would have. That's the established precedent of the Court of Appeals in Ventricelli, in Sheehan, by this court in Agurto, and the lineage of cases dealing with pedestrian knockdowns in crosswalks. So in Ventricelli, for example, there was a defective trunk. But for the defective trunk, the driver and passenger would not have been behind their car in a parking spot. They were there to close the trunk. Because they were there, when the car plowed into the back of that car, they were struck. The Court of Appeals said that is not sufficient to establish proximate cause. And the reason is it merely creates the condition for the event to occur. It is not its legal cause.
So you're saying that the fact that she had no supervision at the time is irrelevant because the cause of the accident was the other vehicle running the light?
Undisputedly. And it would be different were there an evidence or claim that had the aide been with her at the time of this incident, the aide could have done something. The aide could have avoided it. But the established expert testimony, it is undisputed that the interval between impact and this car being propelled into this person was less than a second, 0.6 seconds, that no person with her, protecting her, near her, could have done anything. Had the aide been with her, they both would have been killed.
Wasn't the plaintiff's expert saying that she wouldn't have been at that location at that time had the aide been with her?
Right, which is exactly the situation in Sheehan with the bus would not have been in that location had it pulled fully into the bus stop. Exactly the situation in Ventricelli where the driver would not have been outside of his car. Exactly the situation in Agurto where there was an accident that the driver was struck, had to pull off onto a shoulder. But for that accident, the driver would not have been on the shoulder and was on that shoulder when a truck plowed into the shoulder. And what the court said is that the driver on the shoulder was in a protected place, was in a reasonable place. That severed causation. That the first accident, although but for it occurring, the driver never would have been on the shoulder. The fact that the driver was on a shoulder, an area where cars are not permitted to go, severed causation, which is exactly what happened here.
No, but it's a little different here because the video shows that originally, I mean, this is a woman in a walker, and the video sort of kind of can be seen as her crossing at least part of the walkway against the light. She's crossing, right? So I don't think you can say as a matter of law, not having an aide there would have changed that configuration.
Right, so what they're claiming here is that had the aide been there, the decedent would not have crossed against signal crosswalk 1, and that would have changed her timing. And again, changing timing.
Or may have walked in a different way or done any number of things you do differently when you're with an aide than when you're by yourself on a walker.
Correct.
Right?
So
Walking across the Grand Concourse, I might say. It's not just like a little street. We're talking about the Grand Concourse. in the Bronx.
unquestionably. And so that does get into the speculative nature of cause and fact, because although plaintiff disputes this, but for causation is not sufficient, but it is necessary for proximate cause.
Thank you, counsel. You'll have more time on rebuttal.
Thank you, Your Honor.
May it please the court, Patricia Lynn Ford for the respondent.
Ms. Lynn, was there any record evidence concerning sight lines so that a second pair of eyes might have perceived the speeding car sooner than the elderly decedent?
There is no such evidence to that, Your Honor, but that's not our essential claim. Our essential claim is that she shouldn't have been where she was, that if an aide had been with her that day, that there's no evidence in the record that she would have been where she was. And that's defendant's burden on a motion for summary judgment.
Didn't they meet that burden? Didn't they produce sufficient evidence to establish that the fact that she was where she was is not the cause? The cause was the other vehicle striking the rear of another vehicle and propelling it into this plaintiff.
There were two causes to this accident. That is plaintiff's essential cause, Your Honor.
So that's, yeah, that's the question. What is the proximate cause between what are you alleging is the connection between the aide not being there and her being hit by a car?
Well, if I can answer that by two, I didn't mean to interrupt, Your Honor.
That was hit in the rear by another car, right? What is the linchpin there?
The linchpin is the scope of the defendant's duty. And
No, I'm not talking about, I'm asking you, what is the cause between the aide not being there and the accident?
well, the linchpin is, under Haynes, you have to say, was the defendant's injuries as a result of that accident reasonably foreseeable? Was it a reasonably foreseeable consequence?
That's a different thing than proximate cause. I'm talking proximate cause. What is the connection in terms of proximate cause of the accident between the aide not being there and this other car running into a car and what was a horrible, terrible accident? We all saw the video.
I see your point, Your Honor. It's plaintiff's contention that there's no proof in the record that Ms. Hendricks would have been there
But
had the aide been with. There's no proof whatsoever what route they would take.
counsel,
what
she
modes of
was not struck by the vehicle because she was crossing the street against the light. The light was red. It was proper for pedestrians to cross, and she was doing exactly that.
But I think we have to hold the defendant responsible for their breach of their duty and not being with her. And again, it's
But if they were with her, could they have prevented that vehicle from striking her?
I don't think at that moment, and that's not our contention. Our contention is there's no proof in the record she would have been there at that time, but there is proof in the record that she would not have been there at the time. That if Ms. Fair had gone after her and brought her back, she's estimated it
Aren't we
took her about
speculating?
5 minutes.
I don't-
That's no less speculative than saying that defendant's theory is if the aide had been with her, that's a hypothetical, at that moment. And there's no proof she would have been. There's nothing she could have done. There's no proof in the record that the aide would have followed the same route, would have taken the same buses, would have followed the same modes of transportation. But there is proof in this record that's undisputed that if Ms. Fair had gone after Mrs. Hendricks, that would have taken, she says, 5 minutes. It may have taken more. Or if she had said, don't leave yet, they would have gotten to the accident scene even if they took the exact same route after it had happened. That's the essential contention, and I think a jury should decide whether to accept that or reject it or to assess liability
Or
on the.
if she did not go out of the apartment that day, then she would not have been at the accident scene when it happened.
She would have been delayed in getting there, even if they took the exact same route. She would have been there after the accident. That's basically the theory. There's no other questions?
Thank you, counsel.
Thank you.
So briefly in rebuttal on the theory of the route, there is no claim that this was a wander case. She was going to her daughter's office, which was a block away. She was where she otherwise would have been. The only claim is that according to plaintiff, she would have gotten there at a different time. That means that every taxi driver or bus driver that speeds and gets their pedestrians or passengers to a location where when they get out of the bus, a bullet happens to strike them inadvertently, that bus driver is responsible, right? Because had the bus driver driven the speed limit,
But that's different because there's no duty there to get there earlier or get there later. This is a case where someone had a duty to supervise and failed. There's clearly a duty of the aide to supervise, right?
100%.
It's not just that, oh, she would have been there 5 minutes earlier. Or
No.
the sort of the idea is if she had supervised her in a way that she was required to do, then this accident would not have occurred.
But
Not
that-
if she showed up 2 minutes earlier.
No, I completely understand, and that's the issue, right? If they had traveled together and got to the crosswalk 1 a minute earlier, they would have crossed exactly as she had. They would have reached safety zone 1 exactly as decedent had. They would have reached crosswalk 3 exactly at the time decedent had, and they both would have been stricken. The bus driver has a duty to safeguard its passengers, and every bus driver then that goes through a red light and winds up at an intersection. Let's take the Malibu that was propelled into this intersection. Had that Malibu been speeding, and the only reason the Malibu is at that intersection is because the Malibu has been speeding 2 blocks before. That Malibu, but for speeding, would not have been at that spot. That, under New York Court of Appeals law and the repeated precedent of this department, including every pedestrian knockdown case, where a pedestrian, in order to establish freedom of negligence, does not have to prove that pedestrian didn't cross a prior crosswalk against signal. People
Thank you,
do that
counsel.
all the time.
Thank you both.
Thank you, Your Honor.
M. Justice. Please.
May it please the court, Center for Family Representation by Charles Rosenberg for Appellant Antoinette T. The proper reasons for a dismissal without prejudice is to allow the petitioner opportunity to refile the pleadings after correcting some defect or gathering additional evidence. Here, where ATS's withdrawal without prejudice occurred on the date of trial after 2 years of intrusive court-ordered supervision, and where the outcome of the fact-finding would have been binding on Ms. T's administrative hearing with the state central registry, that was improper, unfair, and prejudicial to Ms. T to allow them to.
The court has broad discretion under CPLR 3217, though. You'd concede that.
Yes, they do have discretion, but it's not complete open-ended discretion. There are standards that must be considered in terms of whether it would be improper, unfair, or prejudicial, as well as.
And is the prejudice, you're saying the prejudice is OCFS hearing, right? That somehow that's less fair to her?
Well,
is that correct? That's your argument?
It's part of it. That's definitely part of our argument, Your Honor. The parties at a fact-finding hearing in family court have the right to counsel. The rules of evidence apply, and a fact-finding and a family court judge decides the case instead of an employee of OCFS. But also the 2 years of supervision that she was put under, only to have on her day where she was to hold ACS to meet their burden, to have them withdraw without prejudice on the day of trial. That's also unfair.
Well, did the court put on the record its reasoning for basically dismissing it without prejudice, such as her not being compliant with treatment, refusing to participate in toxicology screenings, and testing positive for cocaine and marijuana?
Well, I would argue that, number one, that has no bearing on whether or not ACS would be able to refile in the future. Their fear was backsliding, and if she did backslide, they could file on those allegations about her backsliding, not on. They wouldn't need this to be dismissed without prejudice to do that. Secondly, it was internally inconsistent because they were ending the case because because they essentially said that they had no concerns that required court supervision to continue, but they're saying that they also have these concerns. So it seems to be internally inconsistent, their argument.
Thank you, counsel. You have time in rebuttal.
Thank you.
Please.
Good afternoon, Justices, and may it please the Court. My name is Michael Weinstein. I'm here on behalf of the Neighborhood Defender Service of Harlem, representing the respondent Robert M. You raised a really important question, Justice Scarpilla, in terms of, Justice Moulton. I'm sorry, it's really my bad. In terms of the broad discretion under 3217, when you're, sorry, that really threw
We
me off.
both wear
I know,
glasses.
I'm so sorry, I know. And I wear glasses too, so we all understand. In terms of the broad discretion under 3217, specifically what was implicated here, because the hearing was already on for fact-finding before Judge Obomalayat, was 3217B, requiring the court's permission and consent amongst all counsel. The information that was put on the record that day solely by ACS was that they did not see a need to supervise this family further. Not only that, we had the attorney for the child affirming that on the record. The only new information that Judge Obomalayat had that
Counsel,
day,
that was, it seemed to me based on the record, that was because the child was thriving, and that might have been in spite of the parents' noncompliance with things that they were told to do by ACS. I'm not saying that was necessarily the case, and that's not before us, but isn't that sufficient to give the judge pause?
Sure, I mean, it's sufficient to give anyone pause, particularly given the purpose of the Family Court Act in 1011 to protect children. But there is still a floor, it's not bottomless. Here, the children were thriving, as you said, and there was no need to supervise further, as my colleague across the table said. If there was a need to file another petition, they could have. Here, there's a directive that the legislature put in the Family Court Act in 1051C that says, if the court makes a finding that its aid is not required, then it shall, meaning must, dismiss the case. That was the order that was avoided specifically by seeking a withdrawal here. The court only had that information, made that determination, still allowed the withdrawal, but under the wrong provision of law. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Jonathan Popolo for Respondent ACS. To pick up where my colleague over there left off, there never was a motion for a 1051C dismissal made, so there was nothing to sort of respond to. I mean, there's a preservation argument issue there as well, because they're raising an argument on appeal that wasn't raised below. Other infirmities with that are there was also no finding by the court that its aid.
I mean, they're making this other point, obviously, that ACS could have brought a new petition. There was no need to dismiss this one without prejudice. You just bring a new petition. In fact, you did bring a new petition. No allegations in the prior petition are alleged in the new petition. And so isn't that the proper way to proceed?
It can be, but they should have, and properly, in the family court properly allowed them to preserve the ability to still use I mean, at some point allegations become stale, but this was only a couple months later. They ultimately did opt not to include the prior allegations, but they could have. They would have had to prove them in the next fact finding. But then, but then they're in a situation where you can't argue. If it's dismissed with prejudice, then it's like it never happened.
Is that the practical effect for ACS, that they have the option of including it? Is that why they would move in the way?
I think that could be part of it, Your Honor. I think there could be circumstances, and I think this is what the family court was concerned about, where the child's condition may deteriorate. There may be things that arise that would show a need for sort of more involvement in supervision, but might not warrant the filing of a new petition on new allegations, but then you could refile the original petition. One other point I did want to make was with respect to the supposed unfairness of having to proceed in the OCFS administrative hearing. I mean, first of all, the standard is whether there's a prejudice to a substantial right. And the Court of Appeals has recently reaffirmed that these administrative hearings comport with due process. And it's important to note that there are lots of situations where there's an indicated report and ACS doesn't file a petition. So in all those circumstances, there's no way you can get the irrebuttable presumption from a finding in a family court fact-finding hearing. The vast majority of those parents have to proceed in the administrative hearing. There's nothing unusual about that.
Thank you, counsel.
Good afternoon. Lawyers for Children by Shreem Nothenberg on behalf of Justice M. And what I want to pick up on here is the notion that the argument appellant is making is that she was made to do services, and therefore, having undertaken those services, it's no longer appropriate for this case to be hanging over her. Because what does she say? She talks about how burdensome those services were, how they were so invasive, how it was that she was being treated unfairly. They created a prejudice to her. But what did those services in fact do? For 2.5 years, those services brought that family to a place where ACS was willing to say, let's step away. If you look at the transcript, the AFC says very specifically, now Justice is getting PT, OT, which is physical therapy, occupational therapy, speech therapy. The house, when the police came to that home, it was found that the child's feet were filthy. Mom was out of control, drunk, belligerent, and violent. Nowhere in anybody's papers does she claim we were going to disprove that. No, what she says is it's just not fair. I've been under the spotlight of ACS for 2.5 years. I need now, as almost like a reward, I should be able to have this claim disappear. That's really just not how it works, though. And to me, it's rather maddening to say the very services that made this child safe are now being held as the reason why the petition should have been dismissed with prejudice.
And I would just want to ask you, I mean, the family court has broad discretion.
There were two hurdles here. Two hurdles. One is the incredible broad discretion, and second, there's a presumption in the statute. So if you've got presumption in the statute plus the broad discretion, one would think that appellant in her papers would have at least addressed head on the very first thing that came out of this bench's mouth, which is that there were real concerns here. Mom had tested positive. Not only had mom tested positive, she said, I'm not going to undergo any more drug testing. So when you're faced with those kind of hurdles, can you really say it was abuse of discretion? I don't think so. The family court was able to make this discretionary decision in order to protect the child, and I ask that this court affirm. Thank you.
Thank you, counsel.
So,
Addressing what the AFC said last, there's such a large amount of discretion, such a wide amount of discretion that the court has. How can we find this was an abuse of her discretion?
well, for a few reasons. One, it was effectively forum shopping. ACS had, for over 2 years, was able to come into my client's home, inspect every nook and cranny of it. They could strip search her children if they wished. It was for over 2 years they had this power. And then on the day of trial, that's the moment that they realized, oh, actually, we don't need to continue to supervise, but we still are concerned to the point that we can't withdraw without prejudice. Why even have a requirement for a fact finding if they can just wait over 2 years, have all these conditions put in place, and then withdraw without prejudice?
I have to say, I come from it from a completely different view. How great is it that after this period of time of services and the children getting what they need, ACS is willing to say, okay, I mean, that's my view of it, right? You're saying what a terrible, horrible thing that for 2 years this woman was doing her treatment plan, and finally, from where she started when the petition was filed to 2 years later, how great it is that she's finally able to be released from that kind of supervision.
Most of the time when ACS feels that way.
We're just talking about this case.
Just to point out, it mostly ends with an ACD, and that would have had a binding effect on the SCR. And that's what should have happened. If they felt like, okay, we don't need to be there, they should have ended it with an ACD, had it dismissed. That would be a dismissal that would have been binding on the SCR hearing. But they kind of wanted to have their cake and eat it too, have the over 2 years of supervision, then withdraw without prejudice on the day that they're supposed to prove their case.
Thank you, counsel. You make that point very well in your briefs. Thank you all. Smartmatic versus Fox Corporation. Please.
Thank you. Good afternoon, Your Honors, and may it please the Court, Aaron Murphy on behalf of Appellant Fox Corporation. When this Court remanded this case with instructions to dismiss the claims against Fox Corporation without prejudice, it identified two paths through which Smartmatic could try to replead. First, Smartmatic could try to establish vicarious liability by alleging facts sufficient to sustain a finding that Fox Corporation wholly dominated Fox News to such a degree.
But the other means was direct liability, correct?
That's right.
And what about the allegations in the complaint, which is a long complaint, concerning Mr. Lachlan Murdoch and Mr. Rupert Murdoch's discussions with the CEO of Fox News and the pressure that, as alleged, they were brought to bear concerning the coverage in the wake of the 2020 election.
So I think the problem is, while we have a lot of allegations in this complaint, there aren't allegations that directly connect to this particular coverage, these particular statements, anything about Smartmatic itself. They're all stated at a much higher level of generality in terms of there were conversations about content, conversations about programming. And I don't think that's enough for direct liability.
But we know, what the defamatory statements were, where they came from, who's uttered them on Fox News. And so therefore, isn't there an inference that's drawn? And also they also allege in the complaint that Fox News had lost some credibility with its core audience and that it needed to take some of that audience back from upstart networks like OANN. I can't remember the other name. You know the ones I'm talking about, yeah.
Sure. I don't think the allegations here are enough to draw the inference of direct involvement in the particular statements at issue here, because they're either extremely high level of generality or they involve completely different coverage. So for instance, they have allegations.
I was going to say, I'm sorry to interrupt you, but while you continue your answer, we know that we have on the book, so to speak, the Dominion case from the Delaware court. Now, I'm not saying we're bound by it. We certainly read that and see that, and the cases seem to be very, very similar on the allegations and whatever, and this is a motion to dismiss. So, how do we put that all into context?
Sure, I mean, it is a motion to dismiss, but it is also governed by the anti-SLAPP statute of New York, that New York has, which was not at play in the Dominion case. The court didn't follow that here. And setting aside the debate we have about that clear and convincing evidence question, even apart from that, this court said the first time this case was before it that the anti-SLAPP statute requires more than notice pleading. It requires the language is such relevant proof as a reasonable mind may accept as adequate to support a conclusion or ultimate fact. And so you need more than just alleging the conclusion or ultimate fact. You need to allege the underlying facts that would allow someone to conclude that there was direct affirmative participation.
And in this very, very lengthy, quite detailed amended complaint, you can't find any of that.
You cannot find, it's a very long complaint, I will grant you that. There are a lot of allegations, but you will not find an allegation saying that anybody at Fox Corporation participated in the actual composition or publication of these statements. The only times you see anything like that, it's coupled with statements like they are directly responsible because they exercised editorial control as a general matter over content at Fox News. And that, once you start saying all we're trying to allege is you generally took an interest, you sometimes exercised control over content, so therefore we're going to infer that you always exercised control over all content that was ever occurring on Fox News, that's not a reasonable inference. That's an effort to impose vicarious liability under the guise of direct liability. It's saying you're the parent, and sometimes you took it, as parents do. Sometimes you got involved in what the subsidiary does, and that's good enough. That doesn't work under either defamation law or corporate law, because you need this direct participation. And if you look at their allegations, when they have—
What about, counsel, let me interrupt you for a second. What about the allegations that after they received criticism, that the news was critical of then candidate Trump, that Fox Corporation employees directed Fox News Corporation employees to play up and air all these Smartmatic machine conspiracy theories? That's straight up. You might not, that might not be borne out after discovery, but those are allegations that would support a straight-up defamation claim, because the corporation obviously speaks through its employees, and if those employees are telling the publisher, this is what I want you to publish, there are plenty of cases that say that that's sufficient to plead a defamation claim in New York.
And if they really had an allegation here that said, at this particular instance, somebody from Fox Corporation said, publish these things about Smartmatic, we'd be having a different conversation. They don't. They have much higher level allegations that say there was a general desire and expression of interest in changing the tone and narrative of coverage about the 2020 election. That is a huge universe of content. They have 5 pages in their own complaint where they detail all of the different types of allegations about the 2020 election that had nothing to do with Smartmatic, with Dominion, with election technology. They're completely different allegations about things like, ballot dumping, absentee ballots.
But let me interrupt you again. The complaint says specifically the Murdochs told Fox News Corp to air these theories.
It's carefully worded to always say to engage in a disinformation campaign.
But we're not going to parse
including
it
but
like
not
that.
limited to
We're not going
this.
to parse it like that on a pre-answer motion to dismiss.
I think under the anti-SLAPP statute in corporate law that you are required to imply a higher standard that asks for more than the ultimate conclusions and says, do you have real factual basis to haul the parent company in that didn't participate in, that didn't publish, everyone agrees.
No, didn't publish. Not there. That's it.
Do you have an
Didn't
actual
publish.
basis beyond just parroting what this court said you need to establish? And what they have when you get to the parts of their complaint that are saying specific facts that they're alleging just are not facts that have anything to do with connecting anybody at Fox Corporation to specific allegations about Smartmatic.
Thank you, counsel. You have time in rebuttal.
Good morning, Eric Conley on behalf of Smartmatic. There is a very simple case going on here where we have 2 corporate defendants responsible for committing a tort. Fox News Network is responsible because their officers and their employees published the disinformation campaign and published.
We're talking about 2 separate corporations here that represent corporations that observe corporate formalities. I don't see the vicarious liability at all. So if you want to unpack that for a moment, you may. Or if you want to stay on direct liability, you may as well, because it seems like your emphasis is on direct liability.
My emphasis is on direct liability because when you look at Fox Corporation here, and our allegations are throughout the complaint, what we have here are 2 executives of Fox Corporation, Rupert and Lachlan Murdoch, specifically directed Fox News Network to spread disinformation about Smartmatic and directed them to publish the defamatory programs at issue. I'm happy to rattle off all of the citations in our complaint, but we are very specific throughout our complaint that what the Murdochs instructed Fox News Network to do was to embrace and to publish disinformation about Smartmatic, and we allege that they did that in connection with these specific defamatory programs. So a direct liability case for their affirmative role, we lay out in spades throughout our complaint. The vicarious liability case is an odd fit for what we're talking about. When I step back...
Bad fit. It doesn't
bad
really
fit.
go anywhere.
We can call it a bad fit,
right?
too.
There's no intermingling. There's no, right?
No, and that's
You've
not
read
really
it?
why...
Okay, good for you.
Let me unpack it a little bit here, because absolutely right. I think they adhere to formal corporate formalities. That's not why we kind of invoke the whole control doctrine. When we are talking about the domination and the control that the Murdochs had over the messaging at Fox News Network, we are doing it because it creates a reasonable inference to support our allegation that they gave direct orders with respect to the Smartmatic allegations and the Smartmatic programs. It also is circumstantial evidence that they would have engaged in and they would have participated in the publication of these specific defamatory programs. I am not going after vicarious liability.
Let me just, you did plead it as a separate cause of action, right? As
No,
a
we did
separate
not plead
theory.
it as a
Yeah,
separate
I'm saying
cause.
you plead it as a separate theory of liability, right?
We did.
But I would say, I would challenge you to show me where this fits into any of our vicarious liability type situation.
No, I would not be looking for you to invoke what we typically think of as the vicarious liability.
Or ever think of.
No. I'm not going there at all. I think that case law, though, is instructive for us. Because when I read that case law, what that is telling me still is a parent corporation is going to be held responsible when they use their subsidiary to effectuate their objective, when they use their subsidiary to commit the wrong act. And that is what we have here. We have the parent corporation using the subsidiary to effectuate a wrongdoing upon my client, and they don't get to get out of jail free card simply because they used their subsidiary
That's,
to
again,
do it as opposed to
direct
their parent.
liability. That's direct liability, not
I am with you.
vicarious.
And again, I think that is only instructive when we think through the concept of whole control and the fact that you do have situations where a parent corporation is exercising that control. But you are correct. I am not pleading this as a vicarious liability claim. That's not my claim in the case. But I think that case law is still helpful for us as we look through kind of the way they were influencing and controlling it. That's the primary reason that we've got that allegation.
Can you address, counsel brought up several times about the higher standard because in New York we have the anti-SLAPP statute. Now I know in our prior decision in this case, we found that certainly the allegations were sufficient for under the anti-SLAPP statute, but that was when we were talking about the other defendants for and not Fox Corporation. So can you address her claims about the anti-SLAPP statute?
Yeah, let me address it two ways. Hopefully I get it correctly. One, the Dominion decision is still very relevant, and you can ignore the Dominion decision at the motion for dismissal in Delaware. But this also came up at summary judgment, where you do have a heightened standard, and you have a greater scrutiny of the evidence, and you're really trying to determine whether there's sufficient evidence to get to a jury, which is not dissimilar to whether or not there's sufficient evidence for a reasonable person to come to a conclusion. So the summary judgment ruling in Dominion, while we don't have a collateral estoppel issue, is very instructive, even at the heightened standard that we have under the SLAPP statute in New York. The heightened standard really comes more into play also when we're looking at the malice allegations, which I think we've pled in spades. If our allegations, as this court found, were sufficient with respect to the other defendants, we've pled the exact same allegations with respect to the Murdochs. And because we've connected that perfectly, we've got Rupert and Lachlan Murdochs were the driving engine of telling Fox News to embrace the disinformation, including the disinformation about Smartmatic, and they did that knowing that that was false and knowing that it was wrong. So I think even if you apply kind of the additional scrutiny that has been encouraged at the actual malice stage, we are satisfied with that as well.
Thank you, counsel.
Just a couple of points. First, I think we're now all on the same page about vicarious liability, and we would very much welcome this court making clear that this is not the kind of complaint that establishes vicarious liability, because we do read the motion court to have held otherwise.
Right, it's only one. It's only the 17th cause of action, right? Two theories, one cause of action. So,
so
to clarify.
On direct liability, I'd go back to the same point about there is a higher standard here. I didn't hear counsel dispute that we have a higher pleading standard under the anti-SLAPP statute.
Well, he said that they reached that higher standard.
And then was applied in the Dominion case, though. I mean, there's a different standard there. There is a higher standard.
That, but you heard what he said.
Sure, but I think what matters for purposes of why that standard is different is because it requires you to parse out the difference between the ultimate facts, the ultimate conclusions, and the facts that are alleged to get you there. And the facts they allege to get you there here are the Murdochs were taking an interest in things like the decision desk call about Arizona, the coverage about January 6th, the specific factual
I just don't think that those are that's a very, very broad reading of the real allegations, which were that Lachlan Murdoch and Rupert Murdoch instructed, who are two corporate executives of Fox Corporation, instructed these Fox News people and the news station itself to air these statements and theories. You can sort of paint them with a broad brush, but that's what it says. And that may turn out not to be true, but on a pre-answer motion to dismiss, I think that we have to accept that.
I mean, I do think you have to look at the fact that because this is an anti-SLAPP motion, there's evidence submitted along with it. And so you can look at the deposition testimony, the record citations they provide to try to sustain all that. And as we explain at pages 12 and 17 and 19 of our briefing, in our reply brief, that evidence refutes the things that they're saying. The testimony refutes it. And you are supposed to look at the evidence that's submitted in connection with a motion on an anti-SLAPP statute.
Thank you both. Andrew Black against Phoenix Cayman. Counsel, before I start your time, I just want you to know, I know this is a sprawling case, so you pick what, I mean, it sort of goes without saying, but pick what you want to work on, whatever you think would be most effective, because we don't have the 2 hours that Justice Osterhager gave you. Thank you. Please, you can start now.
Understood, and good afternoon. May it please the court. Chris Harwood for defendants appellants. The plaintiff limited partners here have asserted a variety of claims involving time periods and defendants that discovery shows fail as a matter of law, and I'm going to focus on just a few. First, they're pursuing time-barred claims.
On the fraud claim.
On the fraud claim and the conversion claim, particularly the period before June 20th, 2017. And this is not academic because it will result in a vastly streamlined.
When did the fraud claim accrue?
And the fraud claim accrued, inquiry notice, right? That's the question, is when were the plaintiffs here on inquiry notice, and were they on inquiry notice before June 20th, 2017? And the answer is yes. The claims are based on making false promises about essentially unlimited distributions. And November 2014, the plaintiffs stopped receiving the monthly distributions they claim Mr. Garg promised them. Then, from January 15 onward, the plaintiffs claim, their own words, that they received unsatisfactory responses to their repeated inquiries to Mr. Garg. They were ignored or they received unsatisfactory responses, their own words. April 2017, the plaintiffs were told by Mr. Garg's estranged business partner, Mr. Khan, who they claim is actually one of them, an LP, that's a disputed issue, but they were told by Mr. Khan that Mr. Garg was misappropriating their money.
When did they start girding their loins for war?
April 2017, they were so concerned that they put together, again, their own words, a fighting fund to hire counsel and fight Mr. Garg for their rights. And so their question really just boils down to, can equitable estoppel save them? And the answer is no. They've just pointed to one email chain from November 2016. My position, there's no affirmative wrongdoing in that email chain, so that kicks out equitable estoppel right then and there. But I don't even have to go there because, most importantly, everything that I just said about inquiry notice either happened or continued after November 2016. So they're out. Those claims are time barred. And the fraud claim also fails for justifiable reliance, their failure to be able to show it. It's an alternative ground, but there's no dispute. They're sophisticated investors. There's no dispute. They did no due diligence. The most they can point to is one investor's advisor Googled the term CDO. That doesn't do it under the case law that we cited. And importantly, reviewing the relevant documents would have clarified the supposed confusion.
They do allege someplace in their brief that the Ziggy Johnson?
Ziggy Johnson.
Ziggy Johnson's memo is only shown to Mr. Balboa's son. And that should have been shared. And you know, that kind of skepticism would have been healthy to air.
So that doesn't relate to inquiry notice, right? So the time-barred nature. It doesn't relate to justifiable reliance because they didn't do anything. It also relates, that Ziggy Johnson memo relates to the issue of the equity residual, what we've talked about in our briefs, and the pitch materials that they got made crystal clear the riskiness of the equity residual such that the Johnson memo would have been compounding. The materials they got predicted for their 3 CDOs, 0 returns ever on the equitable residual for 2 of them, and for 1 of them, 0 returns for 8 years. Not a great bet, getting 0 for 8 years and then hoping for something that's going to get better, almost a decade in the future. I want to now pivot to another important set of claims that, if it gets kicked, will really streamline this case. There are asserted claims for misappropriation of an asset, ICPAM, to which the plaintiffs here have zero possessory interest, and that applies to counts 6 through 9. These claims, all these counts, premised on the exact same thing. Defendant Triax Holdco's purchase of ICPAM instead of one of the partnership's
PSCI.
PSCI, exactly.
Yeah, which only had an option to buy the day-to-day management and not the assets of.
Exactly, and the assets were expressly excluded from the contract. They just pled this wrong. If you go back to the amended complaint, they alleged that assets of PSCI were misappropriated. They just got it wrong. They didn't read the contract. The contract didn't cover assets. And finally, separate and apart from that dispositive issue on those ICPAM claims, the plaintiffs can't show they were harmed by Triax Holdco's purchase of ICPAM. There's no dispute over two key things. One, the only asset of ICPAM is a portion of the equity residual, and plaintiff's own expert has concluded that the equity residual is worthless. So even if there's zero harm here. I'm gonna, unless the panel has questions, those were the arguments I wanted to
go back to that point. I mean, given that it was Calamari and Garg who owned Triax Holdco, right?
Correct.
And Triax Holdco became the owner of the Triax CDOs, right?
Triax Holdco became the owner of ICPAM.
Yeah, right, which owned the, okay.
It was the collateral manager. So what happened, and this is testimony in the record, the collateral manager, because the PSCI only had the option to purchase the management, and that made sense because if somebody else controls the management of the collateral manager, they could cancel the contracts that were the whole thing that was making this a viable investment opportunity. But eventually, the collateral manager had to be sold. The SEC, it's in the evidence.
Right, they put the kibosh on PSCI, according to you. I don't know if the other side agrees with that. But
they put the kibosh on PSCI. The SEC put the kibosh on PSCI purchasing it, and so somebody else had to purchase it. And so Mr. Garg entered into a note with the partnership where the partnership essentially provided the money so that Mr. Garg could purchase the collateral manager so it wouldn't be purchased by somebody contrary to the partnership's interests. And the partnership was given the collateral for that purchase, collateral in the form of the equity residual, which at that point wasn't valueless. We only know now is valueless.
Thank you, Counsel. You have time in rebuttal. Counsel, I'll say the same thing to you. Wherever you wish to focus, you may. There's so many things to talk about. But your briefs are excellent. I'll say to both of you, thank you.
Thank you, Your Honor. Good afternoon. May it please the court. I do want to focus here, and I think one of the biggest issues that Mr. Harwood just focused on was the statute of limitation issues, particularly with respect to the fraud. Now, I think it's very important that this is a fact-intensive issue, and it's not appropriate for summary judgment. When inquiry notice actually began, that is for the trier of fact, and that cannot be determined as a matter of
we decide that issue as a matter of law often. It's not like we never. We often decide that a party was on inquiry notice. And this is a summary judgment motion, right? So
understood, Your Honor, but in this particular context, it is disputed when the statute of limitations actually started to begin running. It's the defendant's contention that when distribution stopped, then notice should have started then. But at that point, it's our client's sworn testimony, which is in the record, that they began speaking to the defendants and asking, what's going on here?
Well, let's start with the fraud. You said you were defrauded by the offering materials, right? That starts, the time of the statute of limitations starts in 2011, right?
So I think we need to break down the fraud because there's three aspects.
Okay, let's start with the one that I just started, right? That you were defrauded by the offering materials. You got the offering materials in 2011, right?
That's correct.
So that's when that cause of action that's when the statute starts. Now, you didn't sue till 2020, correct?
In 2020.
So way past the 6-year statute of limitation for fraud on that.
Well, that's where equitable estoppel.
Why would you be equitably, how does equitable estoppel apply here?
Well, so that's why I also think it's important that we break down the three elements of the fraud that are within those offering materials, because it's not as though it was just one broad fraud. There's three different elements to those.
But it still all happened at the same time. And we're talking about statute of limitations. So again, the statute concluded in 2017. You didn't sue until 2020. You're asking us to apply equitable estoppel, and I'm asking you why.
Well, here, actually, let me walk that back for a second. The 2-year discovery rule kicks in here. It's not the 6 years. Our clients were not able to discover the fraud until mid-2019, when there was a public filing in a related matter that actually showed the money was being taken by the defendants, that the collateral manager was actually taken by the defendants.
What about some of the inquiry notice dates that counsel brought up? For instance, once they stopped getting the payments and once they stopped getting the financial statements, that wasn't putting them in some inquiry notice that there was some kind of problem here?
Well, at that time, our clients, the plaintiffs, actually did go to the defendants and they said, why are we not receiving distributions? Why are we not receiving financial statements? And they were placated, and litigation was stayed off at that point, and they were given plausible explanations that these are complex CDOs.
I mean, that's not what you pled, number one. You pled something else. You pled that the answers were unsatisfactory. And two, at the same time, you create this fighting fund in 2017, which could not be clearer that at that point, you don't create a fighting fund unless you're on inquiry
Planning
notice.
a fight.
There's a fight. And you still wait 3 years to sue.
No, at that point, they created the fighting fund to be able to retain Cayman lawyers. That way they could get information from a Cayman structure. And they did, in fact, go out and they got walkers. And what happened was they were ignored at that point. But that was just with respect to distributions, not with respect to fraud. They didn't have, they only had mere suspicion at that point that a fraud was occurring. There was a heightened pleading standard for fraud. They couldn't just run into court when you have a heightened pleading standard, sound the alarm. That didn't happen until they actually had facts before them in mid-2019.
May I interrupt you for 1 second, please? That is not your burden. Your burden is not to run into court. Your burden is, once you're put onto inquiry notice, is to inquire, to continue inquiring, to satisfy yourself that it's not happening. And what you plead is that you did inquire and you weren't satisfied with what they said. That's exactly what you pled.
In the pleadings to a certain extent, but then there was a point in time when they went to the defendants and they said, we're working to get accountants. This is a complex structure, and they gave plausible explanations, and that's also sworn testimony.
Didn't, in 2017, Khan provide information to your clients in 2017?
In 2017, yes, they did speak with Khan, but at that point, the plaintiffs in this case, were trying to distance themselves from Khan to an extent because there is a very heated litigation between, I'm counsel in that case as well, between Mr. Khan and Mr. Garg. And the plaintiffs in this case thought these are disgruntled business partners. They have their own dispute. And so they didn't want to get involved. They thought maybe there's something there, but there was no definitive proof. When they saw large financial institutions like PIMCO, Citigroup were suing Mr. Garg, and then there was sworn testimony that money belonging to the LPs was actually being diverted, and the collateral manager had actually been diverted. Then they had the proof that they needed. Okay, Mr. Khan was correct when he came to us. Mr. Balboa was correct. Until then, it was just mere suspicion, and under the case law, mere suspicion is not enough. That's not enough.
Thank you, counsel. You have time in rebuttal.
Counsel's inquiry notice argument fails with the last thing she said. They had the proof they needed. That's not inquiry notice. Inquiry notice is when you are on notice of fraud, potential fraud, such that you have a duty to investigate. If starting a fighting fund is not inquiry notice, then it's hard to imagine what is. And the suggestion that when Mr. Khan told the limited partners multiple times, you'll see in the record in 2017, that Mr. Garg supposedly was misappropriating their assets, that is not distancing themselves from Mr. Khan. You'll look at the emails.
So it wasn't limited to the fact that there were disgruntled business partners, the claims. That's what counsel said. They were disgruntled business partners, and so the plaintiff said, okay, well, that really has nothing to do with us.
Again, we dispute it, but the plaintiffs have taken the position that Mr. Khan was one of them, that he's a limited partner. We have dispute in the record that he's not, but they've taken the position he's one of them. clearly, from our perspective, inquiry notice. I want to shift for a moment to one of the individual defendants, because I'd be remiss if I didn't bring up Mr. Calamari. The claims against him fail for the same reasons that I went over before as to the ICPAM claims, but they fail for additional reasons as well. And, you know, an individual person who has no business being sued based on a misreading of a contract really warrants some focus here. The Count 5 conversion claim, the undisputed evidence in the record is that he was paid the $250,000 that he received for providing legal services.
Those are attorney's fees. But would you, I mean, it seems to me that with respect to corporate waste, they do have a case against Mr. Garg, don't they?
So we certainly have moved on the waste claim, but
that didn't seem to me to be the strongest part of your motion.
My focus has certainly been on what I've raised with your honors today. And, you know, in terms of Mr. Calamari, I would just, we briefed the issue, but the claims fail against him for the additional reasons that we said in our papers. Thank you.
Thank you.
Just very briefly, that Mr. Harwood just brought up is when on inquiry notice that it triggered the timing for them to begin, the plaintiffs to begin investigating. They did start investigating, and that's why they started the fighting fund, was to be able to go out and do an investigation. That way they could, if there was actual fraud, like what was being said by these disgruntled business partners.
But then in 2017, when you do the fighting fund, you wait more than the 2 years. You go a third year. So you see what I'm saying? If you sue in 2020, you get 2 years from when you're on inquiry notice of the fraud, right?
But that's when they started. They started in 2017. They
So
started
within that 2-year period from 2017 to 2019, that's the 2-year period. And then you didn't sue until 2020.
We sued in 2000. Well, it's a disputed fact that 2019 is when they got the information from PIMCO and Citigroup, large financial institutions in the public record, that's when it was triggered. Before that,
it didn't count when you got the information from Mr. Khan, only when it was confirmed by big financial institutions. So you're making that distinction.
Yes, it was mere suspicion at that point, and under the case law, mere suspicion, as I stated before, is not sufficient. Unless your honors have any other questions.
Thank you very much, counsel. Thank you both.
Thank you.
People versus Ralphie Myrie.
Good afternoon.
Hold on, counsel, 1 second.
Sorry.
Right there,
Sorry, Your
Honor.
Honor.
Thank you. Please.
Good afternoon, Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing the appellant. Your Honors,
Where is Ms. Myrie at the moment?
she's currently at 5 points, Your Honor. And
5 points is what exactly?
Sorry?
I'm sorry, she's where?
At 5 points, it's near Seneca Falls.
Ah,
Oh, so she's out, obviously.
No, she's at 5 Points Correctional Facility.
Oh,
She's
5
currently
Points.
incarcerated. And the request here is to reduce her sentence such that she does get out sooner than her maximum expiration date.
Do you know what her, what her time is? I mean, how much longer she's supposed to be in?
Her release date is July 26th, so that would be...
Of 2025?
Yes. And to that point, at 5 Points, Your Honor, when she goes to rec programs, when she goes to the yard, when she goes to shower, she moves through that male facility as a woman. She is the only trans woman at that facility where over 1,000 men are also being held, many of whom are serving sentences for crimes of sexual violence against women.
And did she ask to be transferred to another prison?
She has, Your Honor, and that's up to DOCS's discretion. So the way that it works is, and without reducing her to her physicality, she has all of the secondary sex characteristics of a woman, but she has not undergone complete gender reassignment surgery, and as a result, it's within DOCS's discretion where to house her. And in fact, DOCS is supposed to give her that surgery. She's legally entitled to it, and they have not given that to her over the 6 years that she's been incarcerated in a male facility.
How many times has she asked to be transferred?
I don't know the number, Your Honor. I'm sorry, I don't have that.
They've simply just denied?
They just deny it, Your Honor. And I don't have the access to the reasons why. But the reality is that damage has been done. And that's a lot of damage, 6 years in a male facility. And, the reality of that for her is that she is facing a more punitive custodial experience every single day than the average prisoner would be. You know, we submitted study after study that shows that women in male facilities, trans women in male facilities, face greater humiliation than their non-trans peers. You know, whether it's interpersonal harassment, whether it's more severe forms of physical abuse, trans people are 10 times more likely to be sexually assaulted in prison than their non-trans peers.
Has she suffered any assaults while in prison?
Your Honor, my client has given me permission to share some of the incidents that have happened to her, and if I may, one that I think is especially illustrative, when she was at Great Meadow, which has since been shut down, as the court knows, amidst allegations of abuse and waterboarding by the guards against the prisoners, one incident in particular, corrections officers took her out of her cell, stripped her of her clothes, handcuffed her, and walked her up and down her cell block amidst all the male inmates to be leered at like an animal in a zoo. She has been sexually assaulted, she has been raped, she has faced so much sexual violence that as a result of it, she has repeatedly attempted to take her own life. And once again, that is borne out by the studies, much of which we have learned more of since 2019 when she first was initially sentenced in this case, that demonstrate that she is more vulnerable to that kind of harm than her peers in this facility. And, you know, as I mentioned to Your Honor's point about the refusal to move her, at this point, with an expiration in July, there's really no administrative path to take with that expiration date coming up that will get her out of harm's way. And so a reduction that would effectively reduce her sentence by, 8 months at this point would place her out of this emergency circumstance, but still have the effect of her having served more than 6 years for the underlying offense, which is well within the range that the sentencing court anticipated. And further to your point, Justice Mendez, we don't know that the sentencing judge or defense counsel or the prosecution expected her to serve the sentence where she is. You know, they treated her as a trans woman. They called her by her correct pronouns. They called her by her chosen name. They had no idea, at least based on the record, that she would serve this sentence in a male facility.
What has she sought to be released on any of the grounds that you are speaking of now?
Well, Your Honor, I'm not sure exactly what sort of relief that would entail. Of course, she's had the chance to go up before parole, for reasons that I don't have access to. She hasn't gotten good time, but I think that should be considered in this context that we're talking about.
And what's the reduction you're seeking?
So we're asking the court to reduce to either the minimum or sometime less than what she got, which is the maximum sentence she could have gotten for this conviction, and that would result in her immediate release from her facility.
Minimum is 2 to 4?
Yes, that's correct, Your Honor. But it's also possible to reduce to some term higher than that, but still lesser than the maximum.
Which would be like 3.5 to 6?
I'm so sorry, Your Honors.
I'm just trying to figure this out. If we reduce it from the minimum, but just the maximum, 1 year, that would reduce her, that would allow her to be released now?
Yes, then she would get out, Your Honor.
Okay.
3 to 6 would accomplish a release?
Yes, Your Honor, she would be released immediately. And that is what she needs, Your Honor, because as I mentioned, this is not a safe environment for her. Thank you.
Counsel.
Good afternoon, and may it please the court, Katz Murata for the people. Defendant's sentence was fair and appropriate and should not be disturbed. All the factors that defendant references was known to the sentencing court.
Well, the
court was aware
court
that
couldn't have possibly known what would happen to her after she was sentenced.
the court was aware that defendant is a trans woman. It's unclear from the record if the judge knew what facility she would serve her sentence at. I do think
What
is
happened
more.
to her request to be transferred to a?
I'm unaware. I do think this is more of an issue between, maybe defense counsel and docs could work this out rather than a basis for a sentence reduction. This and the assaults are kind of beyond.
Assaulted at the prison that she's at. That's something that we have to consider, right?
Well, these are all beyond the record. I was not aware of these assaults. Was not on the briefs. On the record, but.
What was the time that she was facing before she negotiated this plea?
So she was originally charged with robbery in the first degree and third degree criminal possession of a weapon. On the robbery count, she could have been sentenced between 5 and 25 years. The time for the third degree possession of a weapon is 3.5 to 7. So she was sentenced to that. But she did, receive leniency by being able to plead down to a Class D felony rather than the Class B violent felony she was originally charged with. Also, she did commit a violent offense. She did brandish a knife at a store employee while stealing items. And it's not her first violent offense. She did commit a second-degree assault in 2013. She's a second violent felony offender.
But she got a sentence of 3.5 to 7, right?
Correct. On the
Has served how much of that so far?
she was sentenced in
I think it was,
July of 2019?
correct. So she's she's served about 5
yeah,
years.
okay.
Um,
Anything you want to add, counsel?
No, if there's nothing else. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just a quick correction, Your Honor, including her pretrial detention, she has served over 6 years, so that's why it would result in an immediate release. Look, the idea that this could be solved between defense counsel and docs, Your Honors, I'm on the phone with docs constantly.
I imagine if it could have, you probably would have done it by
That's absolutely correct, Your Honor. And that's why the incredible power that this panel and this panel alone has to place my client out of harm's way is so significant here. The question of whether she will have paid for this crime is answered. The question isn't whether she deserves prison time in the first instance. It's about how proportionate that is to the underlying offense. And it is a serious underlying offense, and she does have a criminal record. And even that can be seen in a context that the prosecution elides in its briefing. This court and the legislature have acknowledged that a history of abuse is a very powerful mitigating factor for individuals who are not in my client's particularly vulnerable situation. She suffered 15 years of abuse from her mother. And when I say abuse, I want to be clear. Not just beatings, although there were those, being locked in a closet without food, being tied to a pole outside, not to be outdone, her stepfather sexually abused
Was
her.
that in the pre-sentencing report? Is that, that's a
That
part
is,
of
Your
this,
Honor,
right,
that's within the
counsel?
record.
There's in the record. Okay.
Yeah, and if I may just wrap up, this led to a mentality that she had to, quote, fight to survive. And that's been borne out by her experience as a trans woman in a male facility for over 6 years. This panel alone has the chance to place her out of harm's way, and I urge the court to do that. Thank you.
Thank you, counsel. Thank you both. ST1 Realty v. Caroll. You have the floor, counsel.
Thank you.
No rebuttal from anybody.
Good afternoon, Cheryl Corman for the plaintiff. The court just had a fundamental misunderstanding of what it was that this proceeding was about. The court, we simply could not, as a landlord, sue a guarantor in civil
You can't,
court.
I mean, you're outside the jurisdiction of civil court at the
We're
moment.
outside the jurisdiction in terms of the monetary limit. There were no options other than to sue a
But even
plenary
if you
action
weren't, you could still
Supreme.
bring an action against the guarantor in Supreme Court, right?
Yeah, in this case, we were required to.
Yeah.
Well, if the court has no questions, I will not waste any more of your time.
I think, thank you
you.
very much. Yeah. Any questions? No. Thank you.
Thank you.
Narrain versus Society Pass.
Good afternoon, Your Honors. Ethan Brescher on behalf of Plaintiff Appellant Respondent Rahul Narrain. There are many issues in this case. I'll start with first the tortious interference claim, which we believe.
Well, you're very helped by a recent case in O'Connor.
That is very true. With Justice Scarpella was on the
I
panel.
was.
And so,
Probably you should move on from that one, right? May I ask you about the number? Why? What about the number?
Okay, so the number, so in that is the number in that case, the CEO, founder, Mr. Nguyen, testified at his deposition that the price for the shares was $5,763. That was his deposition testimony. In opposition to the summary judgment motion, he filed a self-serving affidavit, which creates only feigned issues of fact, and therefore should be disregarded. There was also another affidavit submitted by his subordinate, Mr. Reno Lang, which we also believe creates feigned issue of fact. And just before the oral argument today, submitted to the court 2 additional decisions, one including where Justice Kapnick was on the panel, the Dixon case, which talks about even where a companion of someone who testifies at a deposition, their affidavit also can create a feigned issue of fact. So there is no basis on which the number.
I mean, Fund Singapore got that price for a nicer kind of stock. So that's one issue that I guess concerning the valuation of the shares.
Right.
And the other is that nobody else bought any of them. So there's no market price. So isn't that sufficient to give some kind of, or create an issue of fact about the valuation of the shares?
They never argued that. They never put in
It's all in the record.
I'm sorry?
It's in the record. I mean, those things are in the record.
Well, they didn't put, in the O'Connor case, they put in an expert's affidavit to challenge the valuation. In this case, they did not put in an expert's affidavit to challenge the valuation. They put in expert's affidavit to put in allegations of lost profits, but not valuation of the damages. So there is absolutely nothing in the record that disputes Mr. Nguyen's testimony under oath that was never corrected, that
He never corrected his transcript, his EBT transcript either, right?
he never corrected his EBT transcript, although it was provided to him. He provided an affidavit which failed to address his EBT at all. These are feigned issues of fact and should be disregarded on summary judgment.
And this is the same price that he stated in the O'Connor case, $5,763?
Yes. In his deposition, in both cases, right? In the O'Connor case, they did get an expert who claimed that there was an issue of fact, and we've had a valuation hearing that we're now completing there. But it was because they got an expert in that case, who in the Narrain case, there was no expert. There's an expert about other damage, lost profit damages on the tortious interference claim, but not on the valuation of the stock. So under the Alvarez case, which controls, there was nothing to dispute Mr. Nguyen's testimony under oath that it was a 5763 valuation. And they can't, and under the Dixon case and the Weilmer case from 2008 from this court, even where someone else comes in and says it's worth something else, that person didn't address Mr. Nguyen's testimony. It just dovetails into his effort to create a feigned issue of fact. So there is no basis to dispute the 5763 price on the stock. They could have brought in an expert.
Okay, right, so if it's an admission and there's nothing to, it's an admission, right? It's a party admission, and you're saying there's nothing that would raise a question of fact as to it. What about the other claims in the?
Okay, so that was our affirmative claim. So on the counterclaims on the tortious interference claim, the board minutes of Society Pass show that the reason that Mega Market failed to enter into a contract with Society Pass was because Society Pass was unable to obtain a digital wallet license.
Well, but someone else testified that the reason why was because your client wouldn't sign a document, right? And that client didn't have, I think it was Singapore, said we didn't have any confidence that the technology was sufficient, right?
Well, with all due respect, Your Honor, Mr. Chan, whose affidavit says that Mr. Narrain knew that what was important to Fund Singapore to invest in was a deal happening with Mega Market. And the reason the Mega Market deal didn't happen.
That's not all he said. It's a question, I'm just only saying that there's a question of fact, don't you think, when the person who was supposed to invest the money doesn't say it was only the e-wallet. They say something more than that, correct?
Well, he says that they felt that that Narrain somehow, because
So
he
doesn't that, I guess what I'm trying to say, doesn't that raise an issue of fact? Maybe.
Well, on the tortious interference, they're saying he tortiously interfered. So Mr. Narrain's refusal to sign the exact IT handbook that Society Pass wanted, they're saying that is the tortious interference that caused Fund Singapore.
Well, also, in that he encouraged other employees to not sign as well, even though most of them did.
Well,
there's that allegation, right? about the IT security pass.
Well, the
policy
evidence was that the evidence in the record is that the other employees actually did sign it, and that the other ones who didn't sign it got a waiver from Mr. Nguyen, that they didn't have to sign it. And those documents are in the record.
Yeah, also the defendants say that there was some evidence that M&M would have agreed to a different kind of wallet than the one that was initially proposed. Is that not, that's just based on nothing, or what is?
That's total hearsay. They never deposed Mega Market. There's no evidence from Mega Market. There's not an affidavit from Mega Market. There's nothing whatsoever from Mega Market. It's complete hearsay.
You need to hear from the source. Okay, thank you very much. You have time in rebuttal.
If it please the court, Michael Nacht for the defendant, respondent, Appellant Society Pass.
I mean, isn't it the question of whether the employment agreement and the warrant are integrated agreements controlled by O'Connor? Isn't that controlled by O'Connor, which found that they were not integrated, that they're separate?
Your Honor, the court did come to that conclusion in O'Connor, so I'd like to discuss the damages. I mean, I wouldn't submit something to the court I don't believe in, but given the court's decision, I think my time is better spent arguing damages. The first item is that the issues raised in Mr. Liang's affidavit are not feigned issues. He spoke to hard facts concerning the company's lack of revenue, its losses, the fact it was going to go out of business, the fact that the Series C price that was referenced by Mr. Nguyen is a totally different security from the common shares, the fact that this company couldn't even sell the Series C shares, which had liquidation preference, and a whole host of other factors that, A, make it inappropriate to assess the value of the common shares from the Series C price, which...
Do we have an admission as to the value of the stock?
So it would be considered, if anything, an informal judicial admission, which is evidence but can be rebutted. And our view is that these were rebutted by all of the hard facts in Mr. Liang's affidavit, none of which were contested. And to that extent, the plaintiff had every opportunity to present some evidence that either...
Let me ask you this. How does Liang explain what he said?
Well, he was the chief financial officer.
Yeah, but I mean, obviously he knows what Nguyen, no, what
Nguyen, I think, but you've been using Nguyen, I think.
I say Nguyen, I'm not exactly...
Nguyen, okay. He says nothing. He doesn't explain at all how that number came out. That's a party admission, and he didn't address it at all.
Well, he's explaining all the ways by which...
No, he didn't address the party admission. When you say, I am going to rebut the party admission, you got to deal with the party admission, right?
Your Honor, again, I think that he presented facts that
Did he say anything about how that number was calculated?
No, and I think that's a problem for the plaintiff.
Isn't that the amount that the investor fund paid for the shares?
They paid for Series C convertible shares, which had liquidation preference, meaning that if the company went out of business, which this company was very likely to do at the time, they would get repaid their investment, which is why it's inappropriate to compare the Series C.
Who put the number on? So you're saying that it's not the same shares?
These are not the same shares. The Series C preferred shares get liquidation preference. So if the company goes out of business...
So Mr. Nguyen, if that's how you pronounce his name, he said this is how much they're worth. When he communicated to the plaintiff, he said this is how much each share is worth.
He said this is the total, which I know this is not on the record, but he's a capital finance guy, and he's speaking about the indicative value.
Again, so then you get your other guy to say, no, here's what they're worth, but he doesn't explain how the number was, how that admission was made, what got put into, and why should he not have to at least address that? How could you rebut an admission without talking about the admission?
Well, Your Honor, I think there's two issues. The first is that what's being called an admission, there's no understanding of any of the assumptions underlying it, and so it's therefore
So then why didn't you put in an affidavit about that?
Well, we put in the affidavit from Mr. Liang, who spoke to the finances of the company, and if I just may make one more point, we have to be cognizant that we're talking about fair market value, the gain that was prevented, and this was private stock. We have evidence that no one was interested in even the Series C stock, and the plaintiff failed to provide any evidence that he could even sell this stock for that number.
Thank you. You have time to rebuttal as well.
I think the issue is that the CEO, founder of the company, Mr. Nguyen, gave a deposition, and he was clear. He also wrote an email to Mr. Narrain on September 4, 2019, saying
Counsel said that was an informal judicial admission. Why would that be an informal admission? Seems to me it was an admission.
well, it's an admission. I mean, it's not in like a court pleading, right? In a deposition.
It was in a
I understand the
deposition.
law.
We consider depositions and things on summary judgment motions, correct?
Yes.
Yeah.
It's an admission. So whatever kind of admission we want to call it, it's an admission by the CEO.
And he's the CEO of the company.
He founded it. He was the CEO, the chairman, and the co-founder, and
In
majority
opposition, did he put in an affidavit that said I lied?
I'm sorry?
Did he put in anything that said I was mistaken, I lied?
I've changed my mind.
Changed
I've
my
come up with
mind.
new
He,
information.
in his affidavit opposing summary judgment, he ignored his admission in his deposition, and he never corrected the deposition. This
So
is
how can you overcome the presumption of an admission unless you
How can he?
directly speak
you
to it?
can't. The law is clear on this, Your Honors. They didn't put in an expert. They had an expert, a well-known expert in New York, Mr. Gottlieb, and he put in a report, and then that's a whole issue of whether the expert who Judge Borak allowed to testify about the discounted cash flow on their alleged lost profits claim, which
He was more like a mathematician, really. I mean, he was relying on underlying data. Who knows if that data will come into trial, but,
I called it a VIG. A VIG is something that, a mobster would use to beat someone up if they don't pay a loan. But that's what in any event.
I mean, he used the word vague, but I think he was just being informal.
He also said it couldn't be found in any treatise. This is not expert testimony. This is just something that he made up.
I will have a closer look at that. Thank you, counsel.
Thank you, Your Honor.
You've got 2 minutes, too.
There's just one thing I want to go back to with respect to the handbook. Mr. Narrain it wasn't that he refused to sign the exact handbook. It was an issue that he was delaying for the purpose of sabotaging the investment to the point where at the last minute he inserted a salary dispute into the handbook, and that's a clear breach of his fiduciary duties. I do want to go back, though, just on the damages for a moment, because I think a deposition testimony is an informal judicial admission. And one of the issues here is that I think the financial data was best put in through Mr. Liang. I think whether Mr. Nguyen puts in the financial data of the company or Mr. Liang puts it in, the chief financial officer, it's sufficient to raise an issue of fact that, no, this stock was not worth that much.
Don't you have to put in something, some kind of evidentiary proof to do that? You can't just say, well, it's worth something else. I mean, you have somebody that puts in proof and states it on a deposition, whatever. He's a party to the case. Something a little bit more than what you've done, it seems to me, had to be put in to raise a question of fact.
Your Honor, I think that
on a summary judgment motion.
I think that was raised in Rose da Akib. I'm not sure if I'm pronouncing it right, but the holding there was that what is sufficient is that we raise a triable issue of fact, and we don't have to affirmatively prove our case. In this instance, would be an alternate valuation. And I think at the end of the day, a jury can look at these facts and say this was a failing company, had no revenue. This plaintiff could not sell a 0.4% of this failing company in restricted private stock into a market that's unproven for nearly $1 million. And a jury is perfectly entitled to reject that contention. Thank you.
Thank you, counsel. Thank you both. People versus Jimmy Feliciano.
Mr. Feliciano was owed a full understanding of the core components of his arrangement with the court. The terms of the agreement needed to be explicitly and unambiguously stated on the record, but the court failed to articulate, in important respects, what would happen if Mr. Feliciano's health improved.
Well, that's not something that anyone expected.
No, Your Honor, it was expected.
It was.
Yes, the medical experts that provided letters between 2014 and 2017 all said Mr. Feliciano, if nothing changes, will die imminently. However, he can have his collection of symptoms managed. And defense counsel was honest about this, especially in the appearances before the plea. But most importantly, not only is the agreement silent on this topic, but there's some implication that he might avoid imposition of sentence altogether.
But isn't that contradicted, though, by Mr. Feliciano's letter to the court, the one where he says, quote, "If my health improves, I go to prison. If it deteriorates, I go to hospital and I wait for death"?
No, Your
Doesn't
Honor.
that show that he did understand the terms of his sentencing?
2 points. So first, what matters is what was told to him at the time of the plea. And second, that letter must be understood in the context in which it was written. So at that point, the parties had already debated for multiple months whether Mr. Feliciano's plea allowed him to be sentenced for improved health or whether he should be allowed to go to a less restrictive setting. And at that point, when it was unclear what was going to happen, for various reasons he relapsed and he was sent to jail. And in that context, it's increasingly clear that something is going wrong. But ultimately, Mr. Feliciano objects to the imposition of sentence, and there were repeated protests. But I just want to highlight a few pieces of language about why this created ambiguity. So the court says, basically he will stay there basically for the duration. It's not clear what that means. Then the court says...
That's what it means.
What?
Until he dies. He's not going to die in jail. He's going to die in a nursing home.
But the sentence, he also at the same time says, if he violates the agreement, the court will impose the sentence that would otherwise be required. So that implies that there's a world where it's not required. And at the same time, the court ultimately closes, I'm going to adjourn this indefinitely until such time as either appropriate to impose a sentence or grant a Clayton motion. And all of these issues are compounded, I think, by the failure to dispel any the indications that Mr. Feliciano is pleading guilty in order to obtain medical care that was unavailable at Rikers Island. And so, this isn't to say that there can't be situations in which...
No, but I mean, are you talking about February 10th, 2017? Where the court says to him, if you do anything, if there's any change, or whether you need to be in a nursing home, I need to know. If you leave the nursing home or did anything improper there, or do anything that would violate this plea agreement, the court would impose sentence.
Yes, I think the one thing that is clear is that Mr. Feliciano is told you have to go to a program where there will be a variety of obligations and you must participate.
And if you don't, then the court will impose sentence.
Yes, but separate from that, there's about 4 months of debate about what should happen.
No, but you're saying he didn't understand that that's what would happen. How could he not understand it?
I think there's
a told it to him.
That's a different issue. Whether the sentence was properly imposed upon the relapse after several decades of substance abuse issues that stem from a lifetime of unaddressed trauma is one of the issues we put forward. But the problem is that Mr. Feliciano needed to understand unambiguously what the core components of the plea were at the time he pled guilty so that he can make an informed decision about whether to plead guilty.
What is unclear about, I'm sending you to the home until such time as 1, you get better, 2, you make a Clayton motion because you want to be released before you pass away, and if you do anything improper or you violate the terms of your plea agreement, I am sentencing you.
Well,
What's unclear about that?
I think a few things. One, an indefinite postponement implies the event might not happen. And I think that's understood both by the Supreme Court and lay people. I think additionally, a Clayton motion can be granted on the basis that there is, it'd be cruel to impose a sentence because no penological purpose would be achieved. But it can also be granted because the person no longer poses a threat. And that is one of the inquiries that is advanced in the Clayton motion itself. The defense attorney explains that, ultimately this is a case where a laptop was stolen and returned very shortly. Mr. Feliciano is facing a life sentence for this, and there wouldn't be a penological purpose of keeping him incarcerated because he doesn't pose a public safety risk.
Thank you. Counsel. You have time in rebuttal as well.
Thank you.
Good afternoon, Your Honors. Hunter Barron for the people. Just at the top, I'd like to point out that all of these claims are unpreserved.
Oh, you're going to say that.
I'm
They're
sorry.
not preserved, is what you say. Both that it's impermissibly vague and also that there was
all
situational
unpreserved,
duress. So that
correct,
those two
yeah.
things were not.
Yes, all of those claims are unpreserved. Yes, Your Honor. And this court did decline to review Mr. Lanzat's claims and People v. Lanzat. I believe Justice Scarpula, you were on that panel, not to put you on the spot, but yes. And in the alternative, the court did reject defendant's claims in that case, and it was really a very similar plea arrangement to this. Just a couple points on the.
And what about the Lopez exceptions? I mean, or how about Lopez? How does that impact this case?
Yes, Your Honor. Well, I would point out that I believe this court cited Lopez in Lanzat and expressly held that it did not apply here. However, on the face of it, really what Lopez is about is a deficiency in the allocution that's clear from the record, and that the defendant had no actual or practical ability to object, and that really wasn't the case here. There wasn't really anything wrong with the allocution or anything that came up that raised questions, and all of the claims relating to duress are not really clear from the record.
None of that would have come to the court's attention in the normal course.
That's right, Your Honor. And of course, defendant had a practical ability to object at any point to this arrangement, even after the court decided to ultimately remand him and impose sentence. Unless the court had any further questions on the vagueness claim, or, okay. Thank you, Your Honors.
Thank you, counsel. Please.
There's several distinctions between Mr. Lanzot's case and Mr. Feliciano's. One of the most obvious ones is that Mr. Lanzot, Rikers successfully treated the underlying medical issue a year before he pled guilty. Here, there was extensive motion practice and multiple pre-pleading memorandums that put the court on alert between 2014 and 2017 that the conditions of confinement were intolerable, which is, in fact, the judge himself observed this is an intolerable situation. In Lanzot, the defense attorney explicitly disclaimed any notion that there was a ground for plea withdrawal at the time of sentencing. In this case, Mr. Feliciano objected to the imposition of sentence once it was clear what was happening. It is also different that in this case, not only did the prosecution oppose for 4 years any compassionate relief arrangement, but they also alerted the court, one, that there was a problem of duress, and they alerted the court that there was a problem in that the court failed to explain what would happen if Mr. Feliciano failed, his health improved. And this court, in the Boyd matter, which we cite in our reply brief, says that when the prosecution brings these issues to the court's attention, that suffices under Lopez. And although there was a lot of time between the plea and the sentence, as the debates sort of show, no one really knew what was happening until it was happening. And at that point, he does object. But in any event, this court can always reach these issues in the interest of justice.
Thank you, counsel. Thank you both. Davis versus Adams.
Nobody here? David.
Curious.
List in front of this. This is an underlying action.
Counsel, you need to be by the microphone. You can take your PC over there if you want, I mean, your laptop.
This is an underlying action filed by petitioner appellant Ricky Davis to challenge the placement of his status on leave without pay arising from his refusal to accept a COVID vaccination.
When was he placed on leave without pay?
The leave without pay was January 11th of 2022. However, Mr. Davis promptly filed an appeal, or excuse me, a request for exemption from the mandate on a form which was provided to him by the New York Police Department's EEOC on February 8th of 2022.
Is that the same proceeding, or is that a different proceeding?
That's not a legal proceeding. That was an internal request with the NYPD to review the decision. So that request was denied. On June 8th of 2022, the NYPD issued a denial of the request for an exemption from the vaccine mandate for religious reasons. On June 15, 2022, Mr. Davis appealed the NYPD's decision.
Right, and that was denied on December 29th. Yeah.
Correct, Your Honor.
So is the only remaining branch of this petition untimely about the leave without pay? Because he's been reinstated to his employment, correct?
Your Honor, so the trial court's ruling was that the Article 78 petition was time barred because it was filed beyond 120 days. That ruling was incorrect as a matter of law because the Article 78 petition was filed 14 days after the NYPD's EEOC denied Mr. Davis's appeal of his exemption request from the mandate. So according to CPLR 78, Mr. Davis could not legally have filed a petition seeking relief with the court of law until the underlying agency decision was no longer subject to internal appeal. So Mr. Davis was required by statute to exhaust the internal appeals process before he could bring the 78 petition, which is what he did. Also, according to the New York Court of Appeals decision in Best Payphones, Inc. versus Department of Information and Telecoms, the Court of Appeals set forth a two-pronged standard to assess whether an agency decision was final and binding. The two prongs have to be satisfied are: one, the position must inflict actual concrete injury. Secondly, the injury may not be prevented or ameliorated by further administrative action available to the complaining party. We cited another case, matter of Pine Grove, matter 2 LLC v. Danes, Second Department from 2009, holding that where further administrative appeal of the challenge decision is available, the statute of limitations to initiate an Article 78 proceeding would not begin to toll. So here, Mr. Davis had fully exhausted his appeals process with the NYPD itself only 13 days before he filed the 78 petition. Therefore, he cannot be timed.
But that, you know, the point is that the process didn't allow for an administrative remedy for the initial leave without pay decision. So that's the question.
That's not accurate. The appeal was taken from the decision placing Mr. Davis on administrative leave because he sought an exemption from the vaccination requirement.
May I interrupt you just for a second? Wasn't it from his request for an exemption?
Yeah, that's what I thought.
Right. So the reason that
he was put on LWAP because he didn't get the vaccine.
Right, and
there was no the only thing. So that was that. There was no appeal from him. He couldn't appeal to his being put on LWAP because that was the rule.
No, Your Honor.
So but he sought an exemption. That's a different thing.
No, Your Honor. He was requesting an exemption from the mandate. If he had received an exemption from the mandate, he could not have been placed on leave because he would not be required by law to receive a vaccination.
He absolutely could have, and then
as a religious objector. So this all goes to that initial decision the NYPD still had the authority to grant the exemption request and then to reverse their own decision on Mr. Davis's appeal to the EEOC office itself. So had they done that at any point in time until December 29th of 2022, Mr. Davis could have been reinstated and could have been awarded back pay if they found that he had rightly been raised and denied an objection for religious reasons from the vaccine. So for those reasons, the 78 petition was timely. He waited until that process was exhausted and filed it only 2 weeks later.
Thank you, counsel. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Elizabeth Friedman, and I am appearing for the respondents herein. Your Honor, number one, the Supreme Court correctly dismissed this proceeding as time-barred because it was filed 4 months after the determination to place him on leave without pay. That's a separate determination.
But you've heard your opponent's argument that the two decisions are conjoined, and so therefore, if he, upon his appeal, and or the appeal becoming moot, that he could then seek leave without reinstatement of the funds withheld pursuant to leave without pay.
Well, Your Honor, first of all, this argument was waived, basically, so the fact that he might be entitled, if in fact he was found to be entitled to a religious exemption, and then would he be entitled to a shorter period of leave without pay, or the pay for that period, that wasn't raised below, but in any event, that is not a relevant determination here for this purpose. So even assuming that the determination, the court did find that it was not time-barred from the denial of the religious exemption request, but it was time-barred for the determination to place him on leave without pay. But, Your Honor, even if, in fact, the court finds that perhaps maybe it's not time-barred, the determination, the petition fails on the merits in any event. And this was very succinctly summarized in a decision that this court decided just last month in Rice-Silco. And in that decision, which I did file, and I have copies.
We have it in front of us, yeah, thank you.
Excellent, Your Honor. That specifically said, that decision specifically ruled, and add that case to the list of cases that we cited in our brief, that in Rice-Silco, this court upheld the denial of the request for religious exemption from the COVID-19 vaccination requirement and found that the challenge determination was not arbitrary or capricious or affected by an error of law, and therefore there was no basis for awarding back pay. We feel that's squarely on point, even if this court does find that this is not time-barred. The Supreme Court correctly held that it was time-barred, the petition, but to the extent it wasn't, the petitioner failed to show that there was any basis that the determination to deny him a religious exemption request was without a rational basis or affected by an error of law.
So if the determination to deny him the religious exemption, which happened on December 29th, right, that's when the back pay would essentially start, right, December 29th? Or?
Well, when he was reinstated, if there was a determination made to award him, to uphold the religious exemption request, he would be reinstated, and then for that narrow period of time
between whenever
of that citywide panel decision and the reinstatement to his position.
That's not the time he's seeking, is it?
No, he's seeking the entire back pay, the entire year from January 11th, 2022 to when he was reinstated, which I believe was February 13th, 2023. He is seeking that period of time for the back pay award. So he was reinstated, but this court has held in these other cases that the underlying request, when the underlying request was rationally denied, which here it unquestionably was rationally denied, he would only be entitled to back pay because he should have been granted a reasonable accommodation, but here he shouldn't have been granted the reasonable accommodation, so he has no entitlement to back pay, even if the petition is timely as to the back pay award.
You're relying on Rice-Silco particularly for that. You really have to unpack what your religious exemption is and not rely on, a short quotation from Scripture. You need to talk about what your church requires and get maybe someone who's an expert on that, and you have to unpack the
It's connected to that extent, Your Honor, if it's not deemed time-barred. And our position is that the Supreme Court correctly dismissed it as time-barred, but in any event, he wouldn't be entitled to back pay in any event in this case. Thank you, Your Honor.
Thank you, counsel. Please, counsel, you have 1 minute.
So let me just address the last point first. The order subject to appeal is only the ruling that a portion of the petition was time barred, and that ruling is clearly incorrect as a matter of law. The trial court relied on the town of Huntington case, which literally misstates and misapplies the law from the New York Court of Appeals on this issue of when an action by an agency becomes final and binding, and that's the standard that I reviewed earlier under the Best Payphones case, which requires a two-pronged inquiry. Number one, is there actual and concrete injury? Number two, has an available internal appeal been exhausted? The trial court here did not get that law correct, and that's why we appealed the order. This other issue of ultimately whether the exemption request has merit, in our opinion, this is a very meritorious request. If there ever was one, this man put a long list together.
I'm sorry for interrupting you. I don't understand. You didn't challenge the original leave without pay. That's not your Article 78. Your Article 78 is he was denied a religious accommodation. That happened much later, and you're seeking back pay based on his initial leave without pay determination.
Your Honor, that's not accurate. That misstates our petition, and that misstates our position throughout the entirety of this action. Of course, we're seeking a review of the entire agency decision from the date of the initial placement of Mr. Davis on leave without pay, and we've clarified that at the Supreme Court level and on the appeal. Again,
would this case be different than the recent case from last month, the Rizzico case? How would your case be different if you overcome the statute of limitations issue?
Well, Your Honor, at this point, again, the only issue subject to appeal is whether the trial court's ruling was correct as to this petition claim being time barred based on the failure to comply with Article 78 and the Best Payphones case. So that consideration is not really relevant for the court on this issue. That should be something that the trial court looks at. If the case is remanded, it should be. But in this case, we feel that the petitioner has a very meritorious underlying claim. He has submitted significant written statement with supporting evidence, and he'll have affidavits and witnesses to provide supporting testimony for that when it goes back to the trial court. The issue here is that the...
Thank you very much. Thank you both. .477 Realty versus The Wing, Soho. Please, counsel.
May it please the court, Eric Pinker. The court lacks jurisdiction over the appellant defendants because they are non-U.S. entities who have no business activities in New York, were not parties to the contracts at issue,
Did plaintiff make a sufficient start about jurisdictional discovery? Should they be allowed to at least take a discovery, and then you can revisit a motion to dismiss?
They did not file a motion seeking discovery in response to the motion to dismiss, Your Honor. The motion to dismiss...
But they could do post-Justice Adams' decision. You could do, or we could direct that discovery be pointed toward jurisdiction.
Your Honors obviously have the discretion to do that. I appreciate that. But the plaintiff, Appellate, did not so request at the trial court level. We introduced evidence showing that the relationship between the parties was extremely extenuated, that the defendant appellants, my clients, have no business activities, property, employees.
What about owning property, though, under that section of the long-arm statute, which is A4, I think, 302A4?
Yes, sir.
They both seem to own property, or at least parts of property. Like they own 37% of, or RCI owns 37% of Refresh, or used to until they went.
They absolutely do not own property in New York.
They own shares of a company that owns property in New York.
Well, fair. And the case law in New York is quite clear that owning an entity, even owning 100% of an entity, is not sufficient to afford jurisdiction. Here, RCI owned 57% of a company incorporated in Delaware that had business activities in New York. IWG, the ultimate parent, 4 levels removed.
But does IWG own property in New York?
It does not.
It does not.
It does not. There's an affidavit on file establishing that it does not own property, real property, or any other assets. No employees, no bank accounts, no transaction of business, and no provision.
What about the use
of
of property?
I'm sorry, Judge.
The use of property?
No use of property, Your Honor.
Don't they rent some space at 250 Park Avenue and operate from there?
They do not, and I'm going to answer that more fully in a moment. For the presiding justice, the site for The affidavit that I gave you is 428 to 429 in the record, paragraphs 2, 4, 6, and 8. In response to Your Honor's question, though, about the location in New York, that location, which is also proven up in the affidavit that I just cited, is a separate subsidiary entity not owned by IWG. I suspect it is far down in the corporate organization chart that's outside the record, but the record evidence shows clearly that that facility is owned by a separately incorporated New York single-purpose entity. And I should add that the operation of a business through single-purpose entities and corporate hierarchies is, first of all, not unusual. It's well accepted in New York. It's protected under the law, and it has been employed by the plaintiff in this case. The plaintiff in this case is 477 Realty, LLC, a single-purpose entity that owns a building at 477 Broadway. So all of the parties here are sophisticated parties that know how to take advantage of and utilize the laws that exist in this great state, and those laws protect a shareholder from being liable for its subsidiaries' debts absent an exception, and I'll talk about that in a moment.
What about transacting any business within the state?
IWG does not transact any business. IWG is...
Well, what about this business that this case is about and these claims? How are you not involved with that?
Yeah, and I appreciate that the record is challenging in this respect. The businesses that began here, Your Honor, was started by a company called Refresh that operated, give or take, a dozen flexible office spaces, like a WeWork, like a Regis, like the Wing. They signed agreements in 2017 with the plaintiff. We were not parties to those agreements. 4 years later, my client, through RCI, purchased a 57% interest in Refresh, the company. And 18 months later, that company, Refresh, failed. My company was in no way involved in forming the business of Refresh, operating the business of Refresh.
Through a subsidiary, you owned 57% of the business. That's a controlling interest. That's more than 50%. Why is that not conducting some type of business in New York that's relevant to the claims that, I mean, these are rent claims, right? These are outstanding rent claims. He's the landlord.
Yes, they're rent claims, absolutely. And the reason is because the law permits entities to organize through single-purpose entities, and the law protects that activity. And the liability for that debt is held only at the tenant level. And here, quite candidly, the plaintiff was well aware of its exposure. They negotiated a separate guarantee.
Except there's an allegation in the complaint that you looted the company to avoid to avoid that. And that allegation, if it is true, is sufficient to support jurisdiction. At least it is an allegation that would support a sufficient start to personal jurisdiction.
Well, I submit, Your Honor, that
there's no doubt that there was a $2,167,986 pullback amount that was not in the corporation anymore, right?
it was never in the corporation. There was no transfer.
I mean, that's not the allegation of the complaint. That's not the allegation in the complaint, which we, on a pre-answer motion to dismiss, must assume is true, correct?
May I respond?
It's up to...
Please. That is the allegation of the complaint, I submit, Your Honor. They refer to it as the holdback amount, and they say that amount was, quote, withheld, end quote, in the complaint. There is no transfer of that amount that ever occurred. It was never in the possession of RCI.
Thank you, counsel. You have time to rebuttal.
Thank you, Your Honors. My name is Ethan Cohen. May it please the court for the respondent. Counsel represents that they introduced evidence in opposition to the complaint, which contained evidentiary exhibits that there was that showing the relationship here that IWG, the full corporate chain coming down to the tenant here. That evidence is a 2-page affirmation of counsel for one of the subsidiaries. It wasn't even an affidavit for IWG or RCI. It's one of the subsidiaries' general counsel submitted an affirmation that's 8 paragraphs long with no with one single agreement attached to it, that's the services providing agreement, that merely says there's 4 subsidiaries between IWG and RCI.
Are we going down the alter ego route now?
Yeah.
I'm just saying that they didn't
so
submit evidence here that there was no connection between IGI. Like,
we assume under the BCL that corporations are separate. You've got to allege, it's your burden to allege something that would show something other than what we assume under the BCL.
absolutely, Your Honor, and that's
The only thing I see is that you say that this corporation caused the subsidiary to be drained of any money that was in there and earmarked for payment of rent.
absolutely, Your Honor. Here, what happened is IGI through RCI obtained a controlling interest in the tenant, immediately emailed the landlord and saying, you're now going to pay us through IWG, and communicated directly through us. And then the allegations in the complaint, which appellant repeatedly admits in his brief, are alleged at page 3 and 4 of his brief, that we allege that they looted the tenant through RCI and IWG. And there's evidentiary and documentary exhibits showing that IWG was the one communicating directly with the landlord and doing this.
You were like taking direct payments or something from their account or whatever, that you had that kind of banking relationship.
Yes, Your Honor. They required the landlord to sign up directly under IWG's payment services, and that payment processing agreement, which is the only evidence that appellant put in the record in opposition to in support of their motion, specifically says any member of the IWG group may provide these services, referring to all of the subsidiaries. That's section 4.4 of that agreement. The parties agree the provider may provide the services through any member of IWG. IWG specifically controlled this subsidiary network and used RCI to, as is alleged in the complaint, to loot this. Here, there's clear smoke here, and this is the pleading stage of this action, and the plaintiff is entitled to discovery to determine what was done here, what is their exact connection. And I think appellant's suggestion here that there's no connection to New York, as this court recognizes fantasy here, that this case is all about their connection to New York. There's several articles and proof that they specifically purchased a controlling interest in this tenant in New York, that they operate these, they have the business practice of providing flexible co-working spaces in New York, and that's their entire business. Just because there's 4 subsidiaries, which, by the way, none of them are identified, the only affirmation is from one of the subsidiaries themselves, saying that that IWG has no connection. IWG didn't put in any evidence itself, proving that there's no jurisdiction here, and the claims are sufficiently stated. Appellant notably didn't address any of the direct emails to landlord or any of the complaint itself. Not only the opposition to the motion, the complaint itself attached all of the exhibits here that show enough to obtain personal jurisdiction over these defendants.
Now, with respect to committing a tort within the state, which is part of the long-arm statute, they say that you failed to identify any of these assets that were supposedly stripped from Refresh or the Wing.
Well, Your Honor,
is that true, or do you not need to do that at this stage?
It's both not true, and at this stage of the action, we've alleged sufficiently that there are transfers. But as Justice Scarpula recognized, there is the holdback amount. There's also a specific email showing that they were IWG was directly reaching out to debtors of the tenant, trying to collect specifically amounts owed to the tenant to IWG. That's in the record as well.
They say about the holdback amount that there was never any contractual trigger to get that money to transfer the money. In other words, it was not, you can't say it was a misappropriation of assets. You can't say it was an attempt to hide assets, anything like that, because it just never became due.
In their brief, appellants admit that has never been adjudicated by any court or tribunal, whether or not they owed that money. That's specifically written in their brief, that's never been adjudicated. It's our claim in the complaint that it was required. There's a letter that we put in opposition from the tenant that specifically accuses IWG of seeking to transfer over Refresh's existing membership to IWG's existing co-working spaces. There's sufficient documentary evidence here at this pleading stage to seek discovery here in this action, as Supreme Court swiftly found here. Thank you, Your Honor.
Thank you, counsel.
May it please the court, 3 points very quickly. First, Justice Scarpalla, in response to your question, at paragraph 23 of the complaint, the plaintiff alleged that there was no transfer of the holdback amount. That, on its face, not as only a jurisdictional point, but as a pleading point, they cannot plead a claim for fraudulent transfer when no transfer occurred. No case has ever held that you can plead a transfer claim in the absence of an actual transfer, and we have certainly found none. And I would direct the court to the language of the DCL, which specifically provides a remedy in the event of a fraudulent transfer, and that remedy is to void the transfer at issue. Here, the transfer at issue never occurred, cannot be voided, and that claim, they failed to state a claim on the first two causes of action. With regard to alter ego jurisdiction and piercing the corporate veil jurisdiction, there are, as I submit, 4 exhibits that they could potentially rely upon to try to show some level of activity in New York. Those are exhibits G, H, P, and U of their complaint. Those exhibits show nothing more than an entity associated with IWG was responsible for handling payments on behalf of the refresh after the stock purchase agreement, shows that an entity associated with IWG sent an automated response directing people to the refresh wind down and sent an automated email pursuing $20,000
But counsel, this isn't a motion for summary judgment. This is a motion to see whether or not there's a basis to exert. You're saying there's no jurisdiction. There are newspaper articles. Your website says, oh, we rent places all over New York. Newspaper articles talking about your presence in New York, not in Delaware, but in New York. So the only question is, are the allegations in the complaint based on those sufficient to at least find out whether or not you meet the long-armed statute?
They're not, and those newspaper articles, may it please the court, are not evidence of which entity did which thing. The client organized through separate entities as it is entitled to do, and those must be respected absent specific pleadings and evidence to support those pleadings to justify piercing the corporate veil. There are 7 alter ego factors. They have met none of them. With regard to those 4 exhibits that I cited, there is an agreement for the provision of platform services, effectively a management agreement pursuant to which my client became obligated to provide those services. A management agreement is not with a non-party is not a basis to find liability or jurisdiction. Thank you.
Thank you, counsel. Thank you both.
I'd be excused, Your Honors.
Please. Enjoy your time in New York, counsel.
Good afternoon, Your Honors. I am Judy Shametzi from Wilson Elster, here for Dr. Katz and his practice. I was going to ask the court if there are any lingering uncertainties about the situation to look at 3 pages, which is 351 going on, 521 going on to 522 and 530. Those 3 pages contain Dr. Katz's description of the procedure and the ways that he placed the staples around the mesh and the double crown situation, and it contains the description of the difference between the circumference and the diameter of a circle.
Right, and Dr. Chamberlain endorses what he did.
Absolutely.
And you felt that the affidavit that the plaintiff, the expert's affidavit that the plaintiff submitted didn't really deal with some of the issues that you raised in yours?
Some very significant issues, most notably surgical judgment, which includes the idea of a margin, both with respect physically, with respect to the mesh, which if you just do the math, the plaintiff's expert simply cuts it so short that it doesn't account for the other side of the judgment, which is the risk. The risk is that this is going to come back. The risk is that the mesh will migrate, which, by the way, it did in the second procedure. It will not lay flat, or it will move entirely. So those are the reasons why a surgeon would choose to use as many tacks as the surgeon deems in their judgment to be necessary. And with respect to the size of the mesh, the plaintiff's expert also fails entirely to address the fact that this was a laparoscopic procedure. And again, Dr. Katz does a very nice job. I was actually just looking at these slides. illustrating the difference between laparoscopic procedure and an open one. And in an open one, apparently you would just take the piece and you would fit it into the hole, like in a light. And in a laparoscopic one, you cover the entire section. So that is why the mesh used in a laparoscopic procedure is larger than the one used in an open procedure, all of which is something that the plaintiff's expert simply fails to address. And for those reasons, I do respectfully ask that the order on appeal be reversed.
Thank you,
Thank you, Your Honors.
People versus Bayez. Please.
Good afternoon, Your Honors, and may it please the Court. Marielle Stein of the Legal Aid Society on behalf of Juan Zubiaga Bayez. The issue in this case is simple: whether concealing evidence is the same thing as destroying it. The law is clear. It is not. This court should therefore reverse the finding of the hearing court, suppress all the evidence recovered from Mr. Bayez's home, vacate his conviction, and dismiss the indictment.
Counsel, didn't exigent circumstances exist for a warrantless entry?
Exigent circumstances must exist to justify a warrantless entry. Here, those circumstances did not exist. One possible justification for exigent circumstances is the destruction or removal of evidence. And the Court of Appeals has made clear that that evidence must be an actual, not just speculative, danger of destruction. And here, that just did not exist.
So the information that they obtained from an informant saying, if I don't get back in there soon, they will know something happened and they will start destroying whatever's in that apartment. And then the officers get there and they start hearing noises. And that is a little difficult to get a warrant on a moment's notice.
Especially in the middle of the night, I think it was.
Especially in the middle of the night, they decide, well, we got to go in to be able to preserve the evidence.
So first, it was not the middle of the night. It was around 8 or 9 o'clock in the evening. And while there was no sitting judge, there is a procedure for this exact circumstance.
Right, I understand, but it does happen a little slower, right? Yeah.
That may be the case. However, to your point, the sounds they heard were not the sounds of destruction of evidence. And in fact, Detective Rodriguez, who is the officer who heard the sounds, did not believe that the sounds of moving furniture denoted the destruction of evidence. He believed that what he was hearing was the sounds of the people inside the apartment opening concealed traps. And the prosecution cites no case, nor am I aware of any case, that suggests that concealing evidence in a trap is the same thing as destroying it.
Counsel, what about, should they have been concerned given that the person that they had arrested, that person's phone was going off and the person had told the police officers, if I don't return to the apartment soon, they're out of there. They're going to destroy evidence or they're going to leave, abscond. So we know they couldn't have absconded, but there are toilets in apartments, there are sinks in apartments, there are places to dispose of drugs in apartments. So given that the phone was going off, what about that?
If they had heard a toilet flush, they could have gone in. If they had heard water running, they could have gone in. The information they had from Santiago was good enough for probable cause. There's no dispute as to that. But in terms of what was actually happening inside the apartment, Santiago's information was just speculation. And in fact, it didn't come to pass. They didn't try to destroy the evidence. They didn't try to escape. The only thing that they heard, and Sergeant Rivera actually testifies on page 284 of the record, that Rodriguez never told him he thought evidence was being destroyed. The purpose of the exigent circumstances exception is to prevent evidence from being permanently removed from the hands of the police. And when evidence is being concealed on the premises, that evidence is still within the police's grasp, especially in a situation such as this, where they were in the process of getting a warrant. All three officers who testify extensively about their experiences uncovering a variety of traps of different types, different locations. The police would have gotten this eventually, but when they went into the apartment, the exigency was not yet ripe.
How long after the arrest of Santiago did the police go into the apartment?
I believe about an hour, Your Honor.
About an hour later?
I believe so. The question before this court really goes to the very heart of the exclusionary rule. The warrantless intrusion into a home is presumptively unreasonable unless there is some kind of justification for it. And that's a very high burden for the prosecution to reach. They have not reached it here. There is no case, as I said before, suggesting that concealing evidence, maybe making it a little harder for the police to find, take a little longer. But that's not the same thing as destroying it, taking it permanently away from the police. There's no suggestion that that was underway. They simply went in too early. And to suggest that the concealment of evidence is tantamount to the destruction of evidence flies in the face of both common sense
So
and
what
the law.
about the police officer's testimony? Santiago told us that if I don't go back, or I mean, how much more could they have received? You're saying they had to actually hear the toilet flush? Their guy who was arrested told them, if I don't get back there, the people in the apartment are going to flush the drug or get rid of the drugs. That, to me, seemed like enough exigent circumstances for them to go back. And they did. And they heard noise. And you're saying unless they actually hear the toilet flush,
Which
it's
it
not
seems
enough?
to me might be too late by then, because then the drugs are destroyed. So if they hear that the drugs are going to be destroyed, they hear that they may be destroyed if I don't come back in, they hear people moving furniture in, they know that something's going on in there, they have to wait till they're destroyed to go in?
Hearing something going on is not enough under the law. What they need are facts.
It's not just that. It's hearing something and someone telling them, if I don't get back there right away, the Santiago telling them directly, if I don't get back there right away, they're going to destroy these drugs.
But what they heard was not the drugs being destroyed, Your Honor. They need facts supporting exigency at the time of the entry, and they simply did not have those facts.
But the information from Santiago, who knows them, who works with them, who was told by them, he says to the police, if I don't get back in, isn't that sufficient information for them to assume that if we don't get in there soon enough, we're going to lose these drugs?
No, it's not. They cannot assume. They need facts. It is a high bar. And for a court to find exigent circumstances, they need facts.
Thank you, counsel. You have time to rebuttal.
Thank you, Judge.
Good afternoon, Your Honors. May it please the court, Connor Burns for the people. The hearing court did properly find that the officers possessed exigent circumstances to justify their warrantless entry. And just to pick up where you left off, Justice.
So was this enough? I mean, we've gone back and forth and back and forth. Was what they heard with the information that they heard from Santiago, was that enough?
Certainly, and I think it's not just what they're hearing and the information they're giving. I think it's in the context of the time of when they hear it. Santiago Rivera estimated that Santiago's trip would have taken about 40 minutes to an hour. So, and all these sounds are occurring, the phone calls and the dragging of the furniture in the apartment are all happening around the time when he should have returned, or past the time that he should have returned.
And he was found with drugs when they arrested
he
him. He had drugs. So this wasn't like,
heroin that
right,
came from the apartment.
right.
And didn't the police try to get a warrant, but they then learned it was going to take a long time, that it was about an hour difference?
Correct, yes. So they were in the process of obtaining a warrant, and they entered the apartment around 9 o'clock. And right before they enter, Rivera, who was the senior officer in the field, estimated that it would have taken another 2 to 3 hours to obtain the warrant, which certainly would have been enough time to stop whatever was going on inside the apartment. And again, I think the timeline is important because all of this is happening. It's not just so. I think if the officers had wanted to just do away with the warrant requirement, they would have just went right back to the apartment after they arrested Santiago and entered the apartment. But I think they did, engaged in reasonable conduct. They waited. They listened at the door. I think they were waiting as long as they could before they needed to enter. They wanted the warrant to be issued, but I think when they were faced with the noise of inside the apartment, and again, they have extensive experience carrying out search warrants, and have engaged traps in the past, and they've even engaged traps where, and Rivera testifies that on one instance he executes a search warrant, they go through the apartment thoroughly, they're not able to find the drugs that he knew was inside. They had to go back to the precinct, speak to one of the defendants, get him to cooperate, to go back to the apartment and open up the trap. So I know hiding a trap isn't tantamount to destruction, as defense counsel argues, but there was certainly a worry that even if they get the drugs in the trap, they might not be able to recover, to locate the traps. That's certainly still a worry, even though they're not flushing them down the toilet, the drugs. Yeah, and I think officer safety was another consideration that they considered. Again, Rivera testifies that defendants often rig traps with razor blades and other objects that could harm the officers when they are executing the search warrant. So I think all of this was factored in, and Rivera considered before entering the apartment. And if there are no further questions, we would ask you to affirm.
Thank you, counsel.
Your Honors, I'd like to just briefly address a couple of points on rebuttal. First, they were in the process of getting a warrant, and I think something this court should not lose sight of is the fact that after they entered the apartment without a warrant, their contact at the Southern District, AUSA Chan, told them that their actions meant that they would no longer be able to get that search warrant. So the Southern District determined that there were not exigent circumstances here and the crime scene had been tainted. And second, as to Sergeant Rivera's testimony about his experience having difficulty uncovering a trap, that's actually an example of him being able to find the trap. This is not evidence that was lost. He testifies, we didn't find it on the first go. We went back, we worked on this defendant. We got him to tell us where the trap was. He discusses infrared cameras, all of the things that the cops have to enable them to find these traps. So he's actually unable to detail a time when something was placed in a trap and that completely came out of the hands of the police. That's just not what his testimony suggests. The last thing I'd like to address is that, just to reiterate, the concern that Detective Rodriguez reiterates over and over and over again as the officer listening at the door is that he heard concealment. His concern is not safety, it's not destruction, it is concealment. And as the prosecution themselves concede, concealment is not destruction, and it is destruction or removal that is required for a finding of exigent circumstances. And that finding, that burden simply was not met here. So for those reasons, once again, we would ask that you reverse the finding of the suppression court, suppress the evidence, vacate Mr. Bayez's conviction, and dismiss the indictment. Thank you, Your Honors.
Thank you very much, counsel. Thank you both. People versus Royce Corley.
May it please the court, Milan Chachanda for the people. Defendant was registrable as a sex offender under SORA for two separate reasons. First, the elements of his federal crime of conviction, the possession of child pornography, were exactly the same at the time of his 2013 conviction as they were in 2002, when the relevant SORA registrability provision was enacted. Second,
of course, the defendant argues that subparagraph 3, a very long enumeration statute, I'll just call it subparagraph 3, is only designed to deal with renumbering of the enumerated statute, the enumerated federal statute. Is that correct?
that is not correct. First of all, I think that is based on North, the Court of Appeals court's interpretation of what substantially the same means, and that's all we have. But if you look at the actual subsection D3
It doesn't use the word renumber, does it?
I'm sorry?
Subsection 3 does not use the word renumber. It doesn't talk about renumbering being the only thing.
No, it says if you have to look at the crime of conviction and the elements of that crime of conviction. Right. Here, that crime of conviction, and I do not think defendant will dispute, as the SORA court didn't dispute below, was the actual physical possession of child pornography. This trial evidence solidly established that it was found in his pocket was found a thumb drive that included pictures and images of a child's genitalia. So there is no doubt, as the SORA court below even recognized, that this 2008 edition of closely related conduct that has no bearing on what his actual federal crime of conviction, as the SORA statute directs us to look at, that was the same as it was in 2002. This accords with the plain intent of the legislature. I mean, the legislature in 2002 set forth 2252A and the possession of child pornography as a registrable offense. And to find that it's not registrable now based on conduct that, again, the SORA court finds not.
Well, the amendment was a response to the Ninth Circuit decision, was it not?
It was because, Your Honors, there are various courts who had, as technology developed, and cache files and what were temporary on the internet and the accessing online, there was a split in courts, and Congress clarified that we've always meant for possession to include something like accessing online. And in fact,
so they added those few words to make it clear.
Exactly. And that's actually in accord what the New York Court of Appeals did. The New York legislature did after the Court of Appeals decision in Kent. In the possession of sexual performance of a child, it had only possession, and now it's added access. And it's still called possession, but it has access, and access is registrable. So for New York defendants to be registrable, but not federal defendants, makes no sense.
Counsel, a defendant is now living in Delaware and is registered there as a sex offender, I believe, correct? So why isn't that moot this case?
Because, Your Honor, at the time of his the registrability determination by the board, he was an established resident. And there's an established case law that says just because of a subsequent move, the review of that determination has not been rendered moot. So that still survives, a review of that determination at the time that he was an established New York resident. And I think our brief says further, even if you were to consider it moot, of course, that the actual right remedy would be vacator in any event of Justice Convisor's opinion. And again, unless there are any questions, I think I addressed the alternative basis, which was also that it's substantially the same. But unless there are any questions, I'll wait for my rebuttal. Thank you.
Thank you.
Good afternoon. My name is John Palmer, appearing on behalf of Royce Corley. I'll first address the merits, and then I'll address the mootness argument here. So we simply ask the court to apply the correction law and affirm Mr. Corley's conviction. Correction law 168-2D3 only requires registration for the listed federal statutes if the elements of those crimes of conviction are substantially the same as they were when that subparagraph was enacted. Here, Congress added knowing access with intent to view to a statute that previously only covered knowing possession and substantially changed
still
those
covers
elements.
knowing possession. It's in the
Of course, Your Honor.
Yeah, disjunctive, right.
And further here, regardless of what Congress said after the fact about whether it was a clarification or some new addition, courts had held that the statute did not apply to merely accessing child pornography as it was written prior to the amendment. And in any event, the underlying conduct here is simply irrelevant to subparagraph 2D3's proviso. The legislature specifically enacted the subparagraph to remove the underlying conduct from the analysis. Everyone who is convicted of these offenses must register unless the statute's essential elements, mixing the subsections, unless the elements of those crimes have changed, and that's exactly what happened here. The proviso asked the court or the board making this determination to compare the statute to prior versions of itself and nothing else. We cannot insert language that we wish the legislature had included in that proviso. This is a clear and unambiguous statute. And there's an important analytical distinction between 2D1 and 2D3, the proviso rather, that illustrates why we look at the underlying conduct for the essential elements test and not this proviso. For the essential elements test, we need to look at the conduct to determine whether it was covered by a New York registrable sex offense. Under 2D3, however, the conduct does not impact whether there's been a substantial change in the elements of the offense that the person was convicted of over time. And finally, as to the merits, Your Honors, conduct, an underlying conduct rather, is particularly irrelevant to this non-divisible statute that was charged in full to the jury, where there is no meaningful question as to the crime that Mr. Corley was convicted of. It would be a different case, of course, if, for example, the Congress had added, an entirely new subsection to this statute, and we weren't sure what subsection Mr. Corley had been convicted of. But here it's clear that he was convicted under 225A, A5B, which includes both possession and now, at this time, accessing the tent of view. And finally, as to mootness, Mr. Corley's relocation to Delaware renders the prosecution's appeal moot. A person convicted of out-of-state sex offense is only required to register based off of residing here in New York State, which Mr. Corley no longer does. And the jurisdiction to hold a SOAR hearing rests solely on a person's residency, the county of residency, and as he does not live in New York, no county has the jurisdiction to hold a SOAR hearing. But it's important to also consider the practical impact of a reversal here in this case. If remanded, the SOAR court could only dismiss the matter or hold it in abeyance indefinitely.
What about the People versus Meltzer case, I know, from the Second Department that was decided in 2011, which says that just because somebody had moved, that would not, they should still go ahead and have the SOAR hearing. And I don't think there's been, that was, they sought leave to go to the Court of Appeals, that was denied. I don't think it's been dealt with specifically here, but why isn't that controlling of what we're thinking about?
Your Honor, Melzer's not controlling because that case was decided at a time where the courts in the state understood that if the board determines you have to register, you must hold a SOAR hearing. I believe something to that effect is in Melzer. And after that, in Leiden, the Court of Appeals determined that SOAR courts, of course, can determine whether someone must actually register without resorting to an Article 78 or what have you. But a reversal here would not serve SOAR's aims of notifying the public of supposedly dangerous people in their community or assisting law enforcement with investigating sex crimes. Even if Mr. Corley be required to provide information to New York State, as the prosecution argues, that information would not be available to the public without a risk level. A person's risk level determines the information that is disseminated to the public. That's as to the hotline, and that also goes to the listing on the registry. And of course, Mr. Corley's information is already available to law enforcement because he's under federal supervision and registry in Delaware. So for all these reasons, we ask the court to affirm or alternatively dismiss the prosecution's appeal. Thank you.
Thank you, counsel.
May it please the court, Mohan Chanda. Counsel kept on saying that the underlying conduct is irrelevant, but that ignores the plain language of the SORA provision that says, look at the crime of conviction. And the crime of conviction here is the possession of child pornography. Now, we can also look at other subsections of 2252AB that also, like the subsection here, talk about two different crimes. 2252A2 talks about receipt or distribution. 2252A3B talks about either advertisement, promotion, or solicitation. So by SORA directing our focus on the crime of conviction, we need to know what the actual conduct was. So it is completely not relevant. That's what the legislature wants. In terms of what North held, North, to be sure, talked more about the essential elements test, but North's analysis was informed by the fact that SORA is a remedial statute. So for remedial purposes, it's different from trying to find out sentencing enhancements, or it's about protecting the public. And to protect the public, you need to know what the perpetrator did and what that conduct is that registrable. So the fact that it's a remedial statute, North says, directs you to look at the conduct, and that's critical, and that comports with the plain language. And then finally, in terms of mootness, registrability is different from notification. As we set forth in our brief, there are obligations that are distinct from notification requirements and level requirements. The case can be remanded and held in abeyance until he comes back to determine his particular level. So that's an entirely different analysis, and registrability survives under established case law. And finally, if this court were to determine that it's moot, we've set out the two reasons that vacator is absolutely imperative. One, because by defendant's own logic, he moved to Delaware prior to Justice Convisor's opinion. So if This court lacks jurisdiction, so did Justice Convisor, and that decision must be vacated. Alternatively, he should not be able to, by his unilateral action, prevent the people from seeking review of an erroneous order. And
You
so,
make that point in your brief, counsel.
Right.
Thank you very much.
Thank you so much.
Thank you both. Okay, Harper versus Alameda, de Alameda.
Good afternoon. May I address the court? I'm Marcelo Almeida, appellant and self-represented. I would like to present 3 key points in my argument. The first point is that the court made a mistake in its fact-finding. The second point is that paid and unpaid fees, according to the fee arbitration program, are covered, which means the fee arbitration program part 137 covers for paid and unpaid fees. And my third and last argument is that the letter signed does not preclude, does not waive my rights to arbitration. There is no language in there on that. So in relation to my first point, that the court's error in fact-finding is that the lower court made a mistake. The lower court believed that the law firm Abrams had sent me a notice of arbitration by certified mailed, as specified in the retainer agreement. But the fact shows that they did not. Even Abrams firms confirm we are not under any obligation to send you a notice of arbitration because you're not commencing an action against you. This is on the records 6164, and the judgment is on the record 529. That's clearly wrong. And therefore, there's a material and significant mistake because Part 137 for matrimonial actions require attorneys to provide the clients with the notice of arbitration. And also, the Part 137 says that the attorney cannot bring an action to recover fees before serving the notice of arbitration by certified mail or personal service. Therefore, Abrams could never have filed the charge in lien. And that's my argument, my first argument. Moratis and Moratis case law embodies all these arguments, and I rely on that case law. The second argument is that the paid and unpaid fees are covered by the Part 137. I paid Abrams for more than $70,000 of legal fees, and I am, according to the Part 137 rules, entitled to arbitrate up to the amount of $50,000, and that covers for paid and unpaid fees. That is very clear on the rules. And lastly, the letter signed in the corridors of the Supreme Court when I was very, very sick, as the record shows, and the special referee actually adjourns the appearance because of that, and there are medical records confirming that. That's the records 236 to 240. Shows it does not invalidate my right to seek arbitration for legal fees. I believe that this letter is total silent in relation to. It does not waive my rights, it's silent on that regards, and therefore I believe the main document controlling all this would be the retaining agreement, which explicitly says that they have to provide with such notice by certified mail, and the decision of the arbitration is final. And second is that, or the law. One last point that I'd like to present to this court, if I may, is that if Abrams firm really believe that
you can hold that point for rebuttal. Yeah, thank you so much, Almeida.
Good afternoon. May it please the court. Megan Buckwalter on behalf of the non-party respondent.
First, with regard to the appellant's position, the lower court did properly find that the fees through December 30th of 2022 were reviewed and approved by the appellant. He had entered into a payment agreement with our firm, which allowed us to stay on the case and continue acting as his trial counsel in an ongoing trial before special referee. And in doing so, he elected in that payment agreement to review his invoices on a monthly basis. And if he approved them, he would sign at the bottom where there was language that specifically said, I've reviewed and approved these invoices, that he's agreeing to the balance in the invoice. I know that the appellant understood this because he then stopped doing that while we were still actively on the case before there was any issue as to us coming off the case for a few months. From December 31st until the end of February, he was issued 3 more invoices and he chose not to sign those. Those are the invoices that the lower court properly determined would then be subject to fee arbitration. Because at the time of when we came off the case via a consent to change attorney, there was never any application that we were being removed for merit or that there was a dispute. It was simply that he at that point could not pay the attorney's fees. He retained new counsel, and upon retaining new counsel, raised a concern to us about the validity of the invoices. And it was only at that point that that even came up. However, we filed a notice of charging lien. We did not seek to enforce the charging lien. We never brought an action to set a amount for the charging lien. It was only 4 months after that the appellant filed a motion seeking to vacate our notice of charging lien, wherein the lower court decided to determine a sum certain for the amount of the charging lien, and then directed the appellant to rightfully arbitrate the remaining fees that were in dispute. We at no point have decided that we wouldn't participate in that. We never said we wouldn't. We, when the appellant, elected to proceed to fee arbitration, he said, and he cited to 137(6)(c) that he was.
Were you required to send him a notice, and did you in fact do that?
It's our position that when the appellant emailed me specifically stating that under 137(6)(c), he was on his own initiative electing to go to an arbitral body and asked for the information on how to contact that arbitral body, I sent them that information. I gave him the email contact information, the address, the phone number, all of that information was sent to the appellant. He then never at any point filed for fee arbitration. And all we did was file a notice of charging lien. 4 months went by, there was never a fee arbitration that was commenced by the appellant, and it was sort of in limbo as the case was still ongoing. And what has led us to this is that the appellant filed a motion seeking to vacate our notice of charging lien. But yes, we did provide the notice that we believe was due under the fee arbitration rules. We are not disputing that the remaining $14,000 and change is subject to fee arbitration. We would like to go to fee arbitration to finish this, but we do believe that the lower court properly determined the charging lien in the sum certain that was just for the invoices through December 30th of 2022. If there are no other questions.
Thank you, Counsel.
Thank you.
The return agreement explicitly says that upon my request for arbitration, the law firm would be required to send a notification, a notice of arbitration by certified mail. It's very, very clear on the retainer agreement. And secondly, the Part 137 applies for paid and unpaid fees. It is reasonable to believe that if the customer is paying for a fee, it's because the customer has received the invoice, has acknowledged the invoice, has believed the invoice is correct, and has agreed to pay for it. But as the case progresses, the view may change, and the arbitration body, which is formed not only by lawyers but also members of the public, will look into all the case in a holistic perspective to decide whether the fees were reasonable or not reasonable. And when the lower court stepped over that process, it basically invalidates the role of Part 137, is taking over the role of the arbitrators.
Thank you, Mr. Alamaa. Thank you both.